Back. We back. We back. We back. Y'all. Make sure you hit that like button, subscribe to the channel if you're new. And wait till I show y'all this video of Wallow, man. Yeah, Wallow a fucking character. Like, yo, I swear, the more and more you see these guys, the more and more they start exposing their hand for real and what they really about. Like, damn, yo, I used to like Wallow. Thought he was 100. Thought he was 100, man. All these guys really just playing on everybody for views and likes. They ain't got no real message for real. Niggas sole purpose is to monetize on this motherfucker. You heard me? And wait till y'all see this shit. This shit had me dying laughing. 2,800, what it do? Yeah, it had me dying laughing, right? Alrighty, man. Get that paper, man. That motherfucking paper. So look, right? It's always up, Al. It's always the comments. I told you, y'all. The comments is what gets me every time. So Wallow put on a whole performance. He put on a whole performance, and I'm sitting there dying laughing. But you go to the comments, everybody's so serious. Like, I just love Wallow. He's just so real. I'm like, yo. Hey, yo. What's up, Al? Yo, we gotta go into YNW. Melly had his bail hearing today. Also, y'all know that story I covered. It's going viral now. YouTube ain't get my video no play, but it is what it is. That story I covered with the father that got get back on the police for killing his son. He was in court today. Go and check that out. See what the fuck going on with Diddy. Diddy in court today. Everybody's in court today. Melly, yo, Diddy, everybody in court. Then you got Wack 100, y'all. Wack 100 is putting more cases on. Wack 100 is putting more cases on Big U. Like, yo, this nigga is diabolical, y'all. But he's saying he ain't a rat. He's saying he not a rat. Now, I ain't gonna show the video. No, I ain't gonna show the video. But it got something to do with a guy by the name of Money Mitch. Money Mitch supposed to have been murdered. Well, he was murdered. And Wack 100 is making wild-ass claims. And then went and found the video and released the video to the internet. Released the video to the internet. Like, yo, Wack is a wild ass nigga. Hold up. Hold up. Real quick. Yo, share the live. Let's get some people on here, man. Yesterday, let's see if they do it 2 days in a row. We ended up with like 5,000 people. Ended up with like 5,000 people yesterday. You normally be at like 15, sometimes 20, but it is what it is. So let me show y'all what I'm talking about with this nigga Wack goofy ass. On this right here. Nah, right here. Where he gives to the video.
Go ahead, you handle the business. Get him out of the way. Yeah, seems like you guys could have a cordial conversation.
They do.
Brick was forced in a way to.
I feel like he always tried to make.
where I want. But depending on the politics of the situation, I won't come up there playing with him, working for. But let's get and let's dissect this thing. Let's get a little understanding of what's going on. Let's go. R&B was like, yo, I like with Adam, and you know.
Oh, they say that. Now it's yourself. What's happening? No, this ain't the video. Wack was talking about somebody named Money Mitch. Let me see. Talking about Loose Cannon. Loose Cannon. Supposed to ask him about a video. Or Loose Cannon wife or something. Maybe he got it. King Hayes, what it is?
The Adam and Wack show.
With the little shit.
Okay.
I didn't know.
No, you got to go here to get this stuff.
Nobody went to San Diego.
Right.
Okay. So now I'm sitting back and I'm saying, yeah, that's why I'm going to put Money Mike's body on you, right?
Oh, here we go.
Wanted why they wanted it. You know, we're going to kick it off a little bit. I get a call.
Here we go.
From his significant other saying, he said, Big U trying to pin a murder on him. I said, what? He said, yeah, he said something about Money Mike.
Let's go.
I said, I ain't got nothing.
I ain't trying to watch that shit. Let's go to the video. So it was that No Jumper interview where Wack accused Loose Cannon and asking about a Money Mike video. So Wack gets this video, y'all, and releases this video. Hold up, man. And releases this video to the fucking world. Hold on. I'm not young, because that shit is federal. Back 100 a federal informant, man. Like he keep trying to act like he ain't telling. Yeah, but you are telling, my nigga. Open source telling. So let me go back. So he talked about this shit on Adam.
You know what I'm saying? Got to do some business. I'm not gonna tell. He didn't do no lying. When he came, how he came was agreed upon. Calling the police, somebody get caught up, jammed up because mafia, and I'll say mafia back. I'm like, right there. He's on the way there. Business to friendship to nah, bro.
Like, imagine if I had not been able to get a boner because of all this stress. No, that didn't happen. My shit's a lot of people here aren't sober, but you have to at least be.
It's about it.
No, definitely. But I mean, it was a disappointing situation as a result.
To him adding to his situation, right? To send him over the edge, you gotta extremely crafty.
Okay. Loose Cannon has really taken a more adversarial stance against you over the past couple of days. It seems like he's decided that he really wants the smoke.
Yeah, that's a situation. One R&B kind of like got on me. She had been on me. And I think what I did, what I shouldn't have done, because I got a bone to pick with you after this podcast too.
Uh-oh.
What I shouldn't have done.
Do it on the podcast.
What I shouldn't have done was, you know, you hear a bunch of shit and you just don't say nothing. It's like you hearing a bunch of shit I'm doing behind your back and you just don't say nothing. And you look up and it's 5, 6, 7 things, right? And it just one day you just explode.
Right.
So I think that's kind of really what happened. And I'm gonna be real. I'm very crafty with this stuff. Extremely crafty. I'm strategic with it. And I fight these type of things different. When you think it's just a head on, I'm gonna fight you from behind you, from above, and come from up under you. And it's all like mind manipulation, right? And because he's where he's at, and I know him, I know how to push his buttons, what to say, just what to do, just what to expose, to send him over the edge. You got to remember, he has to fight me back on what he says, right? I'm not going to even put him in that type of situation to put himself in the trick bag on that phone. You get what I'm saying? Because once I start jabbing and doing and saying shit, right? At that point in time, me knowing him, he's going to blow a fuse. And then most people would sit back and laugh once he starts to say and do things to twist himself. But to me, it ain't really a laughing situation to contribute to him adding to his situation, right? On top of that, I'm going to be real. I never really played the game with Loose Cannon. You know, when I talk to Loose, I talk to Loose. You know, I never recorded phone calls unless he asked me to. I remember one time he was talking to his dad because he was trying to clear something up for Eddie Boy or something. He like, Wack, record the call so Eddie Boy know I tried. Shit like that. But I never really did none of that with him. Whenever he was talking to me about things. But, you know, it's things I know. It's things that he don't know I know. And maybe I should have told him, right? But all this did for me is kind of say, Wack, you know you should have been put closure to that. And I'm going to tell you.
Just double check. Is the audio for the TV is turned off, right?
Yeah, because I didn't know it was going to start playing.
Oh, okay, because it did start playing. I just want to make sure that they can't hear it. Sorry.
And it was like, it was a couple things that was done that I really like looked at it and said, oh, it's like some sabotage type shit.
What do you mean? Self-sabotage?
Not self-sabotage is when you doing it to self.
Right.
But when somebody that's supposed to be kind of right there with you starts to do things that could affect things that has nothing to do with them but just you, you know, you're supposed to see that. But I kind of dismissed it because it was like,
yeah, hell yeah, they tell him. It's called he open source snitching, man. Like, yo, he trying to say Loose Cannon called him, asked him about a video from the feds. You supplied it. Yo, why the fuck, yo, if my man was to call me from any penitentiary across and ask me to send him a video about a motherfucking shooting, I'd be like, what the fuck type shit? I'd have hung up on his ass. Like, yo, what the fuck type games you playing, bro? Like, yo, that's what I'm saying. Like, Wack tries to distance himself. Like, you know, I ain't got nothing to do with this. Yo, but why are you trying to get videos that allegedly show Big U supposed to been involved in some shit that he haven't been charged with to the feds or to a federal inmate? And then you released it to the world. Like, man, this nigga crazy, man. This nigga work with them people, man. He work with them people, man. That shit ain't even up for debate. He can sit there and try to spin that shit till his head fall off. Nigga know what the fuck you doing, nigga. Open source snitching. That's what Wack was doing.
like you doing with Lush, maybe he wasn't thinking. That's why I know Lush do one more time, think he out of here. Because it get to a point to where you like, nah, after this is gonna be on me.
Right.
Right? Like the situation with Game. Right?
With Loose in game?
Yeah, like when he went that game on the internet.
When did he do that?
I didn't know nothing about that.
That was before you guys were cool?
But he understands that me and Game's relationship, you know what I'm saying? Whatever it may be, like, you've never heard me say anything bad or down in Game. You know what I'm saying?
Clearly care about that relationship.
No, death. You know what I'm saying? Period.
No. You can't trust this fake love. These one of them niggas. Wack one of them niggas that tell you love you when he just met you. Nigga, fuck out of here, nigga. You don't love me, nigga. Yeah, send me over if need be. You don't know what love is, my nigga. At one point, you probably had love for Big U, and then look how you did him.
Right, that's for life, right? So you know, my phone went crazy because people, when you let somebody get that close to you like that, and they do things, they don't believe that you didn't know they were gonna do it.
Right.
You get what I'm saying? So, you know, good thing Game called me. That's how I found out, because he called me. So I called Loose Cannon. Game know me. I called Wack, and Wack downplayed something up. I called Wack, and Wack called Loose Cannon and asked him, yo, what the f is going on? And then Loose told me, man, you know, he was totally wrong with his information. You know, he was, man, I thought this. I said, well, everything you saying is not right. That didn't happen. Game didn't do none of that, right? You can't fault a man for being at a celebrity party. On top of that, I never put the burden on my artists not to do some business if some business need to be done with somebody. You know what I'm saying? If they got to do some business, I'm not going to tell a man not to do his business if it's, you know, worthwhile. They not going to do the business if it don't need to be done, if something's going on with me or vice versa, right? So, you know, I started seeing a few little things, but I was like, you know, I think in my heart, I genuinely was trying to help Loose and trying to, like, show him another way. Like on some genuine shit. You know, look.
Try to show him the police route. It's thinking great. Like, yo, no way. How you sit back and have this frivolous ass conversation with like, come on. I was like, come on, Wack. Come on, bro. Like, cut it out. Cut it out, bro. You know you work with them people. You know Loose Cannon got together and devised the plot with the FBI to take down Big U, nigga.
Looking back at it all and understanding some things I understood, but I just didn't want to call it that. You know, I gave Loose the benefit of the doubt. 10 out of 10 people was telling me things, and I heard them, but I didn't hold it against him.
Wow.
You get what I'm saying? Even the situation here, right? This is my place of business. Like, that shouldn't have happened.
Okay, yeah, you
but
set it up.
You get what I'm saying?
A lot has been.
Yo, this nigga set it up though. Yeah, this nigga Wack full of shit. Like they think black people stupid. Like, yo, this is all this tells me, yo. All this tells me, y'all, is they think black people stupid. They think we can witness something with our own eyes, and they can just explain it a whole nother way, opposite of what we seen, and we just gonna be like, yeah, I see that. Like, yo, get the fuck out of here, Wack. Yo, Wack set that whole play up at No Jumper, man. The whole play. Them niggas, him and Jay Reed was trying to do some type of business together. And it's easy to put Loose Cannon in the trick bag because he's fucking Loose Cannon. It ain't hard to get him to move. And then why is Wack telling a total different story than Loose Cannon is telling about the situation? Like, he trying to distance himself from Loose Cannon when he was complicit with him the whole time. What's up, Trey? Yeah, they've been playing games, bro. They playing with our numbers. They look like black up though in a minute. They might suppress us for like a month or two.
Made of Loose and suggests that he may be a compulsive liar. That's definitely what his brother and his ex-wife have to say. Was there ever a moment in your relationship with him where you're like, holy shit, this fool lies a lot and about things he doesn't need to lie about?
It was things, and I wouldn't say nothing because in my head I can fix it.
And you've been with him, so it's like I don't want to be friends with a liar.
It's a lot of shit. Like it was like
both these niggas lying,
simple shit. But in my head, because I saw him as like and not trying to little boy him, I saw him like a student right? And like, okay, he may don't know how to get in the 3-point stance, but if I keep working with him, he gonna get it.
Right.
Like it was. I can name a list of things, right? But I was like, I can fix it. He wouldn't know it. Sometimes I wait a week and I get in front of him and I tell him. But then another few times it was like, and some shit I didn't pay attention to. Like, I'm like, yo, bro, you got a twin brother? Nah, he's 10 years older than me. I'm 32, he's 42. So I'm like this, bro. If I ask you that, it ain't that I believe you. It's just I don't think you would bullshit me about that, right?
Right.
So that wasn't nothing I was trying to research. People was telling me, I'm like, well, what difference do it make if he is or he isn't, right? But then as time goes on and you start seeing things, you be like, you know, because now when you go to jail, your shit pop up.
Right.
So it's like, damn, you really are 42. So then you ask yourself, well, then what I blow it off, it ain't nothing. It's just he bullshitting about his age, right? Whatever, right? Maybe because he was a artist or whatever, right? The loose cannon, far as him being a producer, I would tell people, no, he really produced music. Like, you know, he didn't produce a couple songs, right?
Do you ever witness it?
No, I never witnessed it, but he would tell me going to the studio and he come out there with a song. Now, as far as he never had a conversation with me about these big names. He would just say he did this song with Nip and he would tell me he did the song because he didn't produce the song. The song was produced by one of my old producers.
Right.
A dude named Buckwheat. They call him Press Play now.
Okay. Oh, yeah.
Yeah, so that song was produced by Buckwheat. It was him rapping, featuring.
Did I miss the part where he talked about the
But he was narrative on Brick.
the
That he
tape?
kicked Brick out the cell, which I'm like, damn, that was kind of crazy because they was in there. It's obvious they was like running content. We're gonna say we sellies.
Yeah.
It was the other fake shit, which I didn't understand when he kept saying Big U trying to get Brick to sign some paperwork. And I'm telling myself, what kind of paperwork would an inmate have for another inmate to sign on that side of the wall, right?
But it's crazy because saying we're running content is the best excuse for just lying.
Right,
Because as soon as you...
Look, what I tell y'all about that content word, these niggas know what they doing, man. I've been telling y'all that content word is a disguise for fuckery. I mean, oh, it's content. Whole time he sending niggas to prison and shit. Oh, it's content. Whole time he getting motherfuckers killed. That shit is a disguise word that the feds brought to the world. That's why I don't use it.
You say we're running content, that's the perfect way to excuse it.
But see, that's the new wave shit, right?
Yeah,
we're gonna get to
this
that.
is new.
So the thing was him, Big U and Brick was in the same place. Me and Brick are cellies, and I'm getting into it with Big U because he's trying to get Brick to sign some paperwork, right? So I already said, well, I know they're in the same pod or whatever together. Them being cellies, they could be, might not be, right? I left it at that. I never believed that Big U was directly with them.
That would seem massively irresponsible on behalf of the staff.
Yeah, I didn't, you know, but I'm listening to it, right?
Right.
So initially it was Brick went to get some hair grease. Then it went to when he said he rolled Brick out the cell. I think it took a while for Brick to hear about it. And when Brick responded and said, nah, not only did he not roll me out the cell, his hand ain't broke, ain't no Big U here, ain't been no fight. When Brick started like clearing the board, that's when the no, I'm lying. Allegedly, Brick says Luce turned down a fade with somebody from Blackstone. And then Luce turned down a fade with Brick Baby. I didn't believe that either. I didn't believe that, right? So then Luce ramped it up. Yeah, we got rid of you because you was over there trying to screw the transgender. Now I get ramped. It went from asking them for hair grease to now you trying to. But I'm watching it. One thing I can say, when Brick came out to say what he gonna say, he said it all. And he ain't said nothing since then. So at that point, Luce ramped it up. I believe that Brick asked the transgender for some hair grease? Yes. Do I believe that he tried to do some sexual shit with the transgender? No, I don't. I don't believe that.
This already
I
was
don't
a narrative on the podcast, though. At a certain point, there was this rumor that Brick had basically like been fucking with a trans person or some shit, or getting his head
In the penitentiary, right?
So Luce was telling you stuff off camera, and then once you saw them face to face, you didn't have the same energy.
It was, but you know, me knowing what I know now, I see the play, right?
Yeah, I was trying. I might have missed the part because I ain't watched this much of the interview. But he was talking about. Let's go back to what DJ Academics was. The shit we just was watching.
That ain't got nothing to do with Loose Cannon.
Yeah, who's Money Mike?
Here you go, right
This
here.
dude that got unalive, right? I said that has nothing to do with Loose Cannon. Why would Big U do that, right? She said, I don't know, but he says you may have access to a video that can help him show it wasn't him, right? I said, I think I know somebody that may have that video. Let me make a call, right? So,
Yo, get the fuck out of here, yo. Yo, get the fuck out of here, man. You better get your lawyer to track that shit down. Nigga, fuck, that ain't my motherfucking obligation to be. Like, yo, this nigga is crazy. They think people believe these dumbass stories. But then he didn't only track the video down. He released the bitch on YouTube. Yo, track the video down and put the bitch on YouTube, man. More open source snitching.
I make the call. I get the video. I'm not thinking nothing of it. I sent it over to her, right? Because in my head, I'm like, damn, that's fucked up. Big, you finna like pin something on this dude that ain't him.
Okay. Now, to kind of like, hurry up the story, because Wack's going to talk for about 10 minutes about this. So Wack calls me and he tells me, yo, listen, bro.
I don't want to hear
Usually, especially if I'm trying to put the murder on loose, the MIGs or and Wack said, we're hearing about this. That's why I'm like,
we ain't watching that video. Wack 100, a wild ass nigga, man. These niggas police. Police. That's what they are. Federal agents, police, fucking military. I don't know what they is. I know they ain't us. You hear him? But yo, YNW Melly went to court today, y'all. And everybody know YNW Melly been locked up for down there 7 years. Fighting this case. I think his trial started in September. This is actually the first time he tried to get a bail. Them niggas police 2800. We ain't fucking doing it.
She was noticing saying less than 36 hours ago she's going to be testifying as an expert.
But he was in court earlier today.
We don't know what materials she was given to review. We put it by video reports in order to get a substance of the testimony. When was she listed as a witness?
She was listed, I believe, Friday evening after he had hired her. She said he wants to take a 10-minute break and after there was no reports.
She was listed. Stop. You listed Friday afternoon.
I believe so.
Okay.
I court Friday came in and it's not Sunday evening.
So you don't want her testimony to be considered today in the interview?
We're fine bifurcating once we, have enough time to go testify to the morning. I don't want to have time to look into that. But today, with less than 36 hours, we're not at all prepared to have an expert testify.
Is she in fact testifying as an expert?
She's testifying as to basically the second portion of my motion going to the appropriateness of the bond. So I am tendering her up there. She did sit with them. She has information to provide to the court.
She interviewed your client?
Yes,
She's going to testify about that?
Yes, Judge.
And just so you understand, the e-filings in the court's portal came in at 10:31, 2005 for the Sunday evening.
Okay, so the state's objection is sustained. She's going to testify today. You haven't even complied with the rule.
Judge, we can take a short break, and they could basically.
I already ruled this.
Okay.
I'm not asking for your suggestion. But go ahead and make all your next.
That was the only witness that we had
Okay,
here.
so is there any evidence, witnesses, or testimony, or is it just going to be your argument?
Then it was just your argument.
Okay.
Mr. Benjamin, I do have one question.
Yes, sir.
I read your supplement. I certainly understand the position you're taking that the exclusionary rule would apply to the portions of the previous trial that subsequently Judge Murphy has found with evidence introduced in that trial that was obtained in violation of the Constitution.
And suppressed.
Your position is that the exclusionary rule applies, a pretrial release or bond.
I wouldn't call it an exclusionary rule, but
That's what you're asking,
I'm saying it should not be considered by the court because the court, the law in this case is it was suppressed and it cannot be used by the state in any way.
Because I noticed
Including a bond.
you didn't cite any authority for that position.
It's not read or argument that says that it is.
No, I agree. It's an unusual procedural posture that someone's rule on motion suppressed before they rule on a bond.
I'm prepared to argue that, Judge, because the case law is a nullity. It doesn't exist anymore. And I believe, for all intents and purposes in this case, it cannot be considered. Bond is one of those. It doesn't say in the rules of procedure that there has to be a certain order or an order of motions. It doesn't say anything like that. But what it does say is, when a judge makes a ruling and suppresses evidence, it no longer exists for the purposes of the case.
Now, the defense is accusing the state of releasing autopsy photos. Like they leaked it.
There's no law that says except for bond hearings. Hell, it just isn't legally obtained nor available for the state to argue it. Maybe someday the appellate court may change that. But as we sit here today, from the date Judge Murphy ruled, and during all this time it's been up on appeal, it is the law of the case.
So let me ask you this, and then ask the state what their position is on that. But let's say I agree with you. Judge Murphy's order was dated December 21st, 2023. The last paragraph of his order says, the court has not been moved to consider the suppression of specific evidence. It is up to the parties to inform the court as to what specific evidence falls within.
These judges don't like overriding
what
over judges.
specific evidence is admissible pursuant to this order. So I'm going to take a wild guess that you all haven't gotten together yet and decided what is and what is not covered by this suppression order. Might I be correct about that?
No, it's not. Together, we have not. But it's all been argued before the court and fully briefed.
So I'm just talking about right now. Like, this is what I want to know. I read the trial transcript, but I'm fully capable, no different than a Frank's hearing, of disregarding anything that I'm supposed to disregard. So what I need to know is what part am I supposed to disregard? Because Judge Murphy put in his order, you all were going to come up with that. So what part would you like me to disregard?
For DCA, because obviously at that point there would be a definite change in posture depending upon what is ultimately suppressed or if anything is reversed by the court.
Right, so it's fine.
Well, hold on. So you disagree with Mr. Murphy?
Yes.
So you want me to consider everything in the trial?
At this point, yes.
If I think that he is right, I'll ask you the same thing. Judge Murphy's order said that you two were all of you were supposed to get together and determine what specific evidence his order was going to exclude and what it wasn't going to exclude. So that never happened.
That has never happened.
Okay. So you want to take their suggestion, give you all a couple minutes and see if you can figure out what this order may or may not cover.
Yeah, I mean, in 10 minutes it's not going to happen because there was a lot of evidence. It was recovered both from all the different models.
There was a lot of evidence.
Oh, yeah, I didn't ask for
Judge, he on some bullshit with the defense. He been on some bullshit with the defense ever since he.
What part of the rules of criminal procedure or the Florida statutes or any case law says that you get to do that just when you feel like that?
My apologies, Judge.
Did Judge Murphy allow that?
No.
I'm not going to. Do you understand what I'm saying there? Do you have any questions that I need to clear up for you on that regard? Everyone is entitled to respect. Everyone is entitled to be heard. One voice at a time for the court reporter. I'm not going to let anyone shout over you or interrupt you or call you a liar while you're sitting at the podium. And I can promise you, I'm not going to allow you to ever do it again. Do you have any questions about that?
Because the state been lying the whole fucking trial. Like they've been undercutting and doing illegal shit since the last trial. Like they got a whole new prosecution team and they still playing the same game. The defense frustrated.
Judge, there was a lot of evidence that ultimately was suppressed. Not all of it was used in the first trial. Obviously, the team now is considering using stuff that is currently subject to suppression that we may end up using in the next trial, assuming the fourth reverses or whatever may come of it. In anticipation of today's hearing, in light of Mr. Benjamin's response or motion, I have a general idea of what's going to be excluded based upon the date ranges that are provided in the order, but I'm not in a position to give specifics, and it would probably take more than 10 minutes to actually go through it. If we were to itemize everything, that's going to be a rather lengthy endeavor. How long would it take? Probably at least a good day or two if we were to sit down and go through everything. That's obviously we disagree that the exclusionary rule would apply.
No, I understand.
What you do understand, bitch?
I believe
You understand? You say you understand everything the prosecution say.
sentence at the end that Your Honor just read is about preparing for the next trial and deciding which evidence that was in the first trial is not suppressed, is not going to be, is pursuant to the.
So basically what they saying is, and I mean, I kind of get what the judge saying. If y'all never got together to have this conversation, how did he know what to suppress through the bail hearing? So what the defense is saying is they don't want certain things brought up during this bail hearing. The judge is saying, well, y'all supposed to got together and talked about this and then presented it to me. Y'all haven't presented it to me, so I don't know what needs to be suppressed versus what is going to be allowed in this court hearing. That's what's going on right now.
I don't believe it is needed to go over for purposes of Your Honor's consideration because it articulates exactly dates and parameters of the evidence that was suppressed. I don't think it says Exhibit A, Exhibit B in that manner, but it does have the parameters of what was suppressed by date and description. So the other part that he wrote, I don't believe changes the suppression motion. It just, I believe, augments it for later consideration at the trial by exhibit number or exhibit letter, whichever they were called it. So I think that's the difference there. And I got to address the state saying that rule says that it's available because he's not entitled to a bond and we can't come back and have a bond hearing. That particular part says he shall be released in those other cases. It doesn't say, and he can't be considered in further bond motions. There's no law nor statute that says, or rule that says we can't come back and argue for his release after a year and a half of what's been going on.
I thank you. That's why I'm here today.
I was always under the interpretation that you can file for bond. Basically, it's a habeas corpus. You can file a habeas corpus for bond reconsideration anytime. You can file 3 of them bitches if you want to. I know in Maryland I think you can file up to 3 of them, but I ain't even sure it's a exact limit on it. You know, as long as if the court willing to accept it, you can file that bitch.
I'm happy to listen to anything you want to tell me. But this single sentence, I don't know that I agree with your interpretation. The court has not been moved to consider the suppression of specific evidence. So do you all want to tell me what you want me to not consider, or do you just want me to take a shot at it myself? I didn't have the benefit of sitting through this motion here. So I don't have an order that says a motion to suppress is granted regarding the defendant's statement. A motion to suppress is granted regarding the cell phone records from T-Mobile. A motion to suppress.
I don't think so. I think he
Regarding
probably gonna
any-
sleep on it. You know how they try and
I don't
prolong
know
and
what
shit.
the specifics are, but I can figure it out. If you're telling me to take a shot, I guess I'll take a shot.
It is
So come back later on today.
amended supplement, the order of judgment.
Yeah, I read it, yeah. That's why I'm asking you.
So if I
I mean,
could,
there's several that say he granted in part, denied in part.
may I clarify this?
Sure.
So if you actually go into the order, a lot of it, the granted in part, denied in part, he goes and talks about the temporal span of this order, saying specifically, highlighted what he said. In reference to his iPad account, that they're limited to a span of 24 hours. Common sense dictates that he did not need to search his iCloud account for evidence and location and communications. So most of these were housed with that there had to be a specific time period. He set that time period from the date of the day, that's October 2nd, up into the date of arrest. So the line of booking Gmail, that was suppressed for the purpose of.
Yo, because the defense and the prosecution ain't getting along. Like that's the fucked up thing about this. You know, they supposed to work together, even though they working opposite of one another. But the prosecution then plays so dirty, the defense don't even want to fuck with them. You know what I mean? So that's really what's going on in this case. Like they didn't play dirty for so long. The defense, like, man, fuck the prosecution. I mean, I don't know how helpful that's going to be to Melly, but that's where they at right now. It was like a standstill. Y'all on that side, we on this side, and we going to figure this shit out.
Period. So anything that predated the deaths.
You probably need to get up and run.
And anything
But
after the arrest.
they've been locked up for 2,000 days
That time period.
fighting
The
the case.
next one would have been Twitter. Twitter was based on the same analogy that the time period was too large and it had to be based upon date of death to time of arrest. When you go to the next motion to suppress, Google was all the way in. Again, I was out for temporal, in part out for temporal. The Snapchat was out from the time period predating the deaths and then time period after arrest.
Just told me. Something unrelated.
I just need to know when the challenge will be available for a change of plea, because when he keeps leaving, they can't call him for in custody.
We were set for 8:30, Judge, and his in custody was not brought until like 16, so I tried to go back to the Okay.
Thank you.
Yes, sir? Go ahead, sir.
Facebook, same thing, granted in part, denied in part. The temporal limitations.
Yeah, especially considering the conditions they got him, man. The boy been on lockup for 4 years, or 3 years or something.
All of Facebook can come in, all of Snapchat, all his text messages can come in. So it was really clear that it was just, everything was out from before the deaths and after.
Yeah, it's happening today.
So that's when you're looking at granted in part, denied in part. It's granted as to the probable cause of the warrant, but it's denied as to the span of the warrant. So really what Judge Murphy did was break it down to where we had a time span of what was relevant and what could come in. His basic, according to basically the cell phone contains their entire life. There was no reason, a lot of these warrants, and even the new warrants that the state has applied for, because they applied for new warrants based on the evidence that was suppressed, they're going back to the creation of the account. Murphy was very clear that you can't go back to the creation of the account. You have to stick within this time period, and that's what he said.
So for example, the cell phone mapping information that was testified to on the day of the homicide, October 26th, that was not suppressed.
Yeah, CDRs are all the way in, yes.
You agree with that?
I agree, Judge. If I can give the court a summary, this is by my interpretation as to what's been suppressed or what can be considered or not considered if the court is going with exclusionary rule. As to the first motion to suppress the T-Mobile records, that was denied. The cell phone location records where the defendant was that day with his phone moving around, that remains in evidence. As to the second warrant, the Twitter account that was granted in part, the past events from leading up to the homicide were suppressed, which means the admission that was made on Twitter is kept in, but the aggravators relating to the defender's activity and belonging with gangs and his gang membership, that would be out. As to count three, or as to number three,
That's one of the things that hurt their
iCloud,
case last
that
time.
was granted in part. I think we noted that there was nothing of import there, so we weren't using
Nah,
anything
I ain't
from
gonna
that.
lie,
We
his
didn't
lawyer's
cover
good,
anything
yo.
from that. To
The main guy not
Snapchat,
speaking.
that was granted in part, again, the day of the homicide, so the location information, the communication records from that day remain in. The messages from the defendant's ex-girlfriend, Mariah Hamilton, those occurred afterwards. Those would be out, but those were not introduced in the first trial. We do intend to use them, but those were not in the first trial.
Justin, you say out? I don't understand, I just want to make sure.
Out. Mariah Hamilton's text message.
You say out.
Oh, so they can't even use them Texas. That's good for Melly.
Subject to suppression. It's subject
They ain't
to
used it
suppression.
last time. But the only reason they didn't use it last time because she didn't come to court. Now, even with her at court, they still can't use them text messages. They're supposed to be Melly admitting to her that he did it.
They're out, that was suppressed. Thanks.
As to number 5, the Google records, that was denied. As to 6, the Facebook account, that was granted in part. Physical location, FaceTime info, connection information, photos from the homicide up to when the warrant was suppressed on January, or when the warrant was applied for January, that remains in. So
Now,
what
see,
the
this-
state
see, this
lost
case
there
different than
potentially
thugs.
are
Like, these
photographs
people-
related to gang.
Like, they trying to get your bad. That thug case was a fucking mess. This a mess too, yo, but they is going above and beyond to try to convict Melly. Like, they lying and doing all type of, they coercing witnesses. They doing everything they need to do to try to get this boy arrested and indicted. Well, he already arrested, but found guilty.
Gang-related activity, the defendant's membership in gangs,
Nah,
as
this a
well
murder.
as some comments and communications
Double
about
murder.
the defendant promoting the promotional video, which is also subject to the appeal, because we argued adoption by admission because he was promoting that video. But all those communications were after January 8th, or at least some of them were, I think. The Instagram, which was number 7, it's effectively the same thing as the Facebook, the gang activity.
Sunday
Number
best, what
8,
it is,
the
pimp,
T-Mobile
before you been
records,
that
the
nigga.
real-time location information, that was denied. Number 9, the T-Mobile records for
They ain't send me
historic
notifications
location
either.
information as to the defendant, that was denied. Number 10 is moot because it was the wrong phone. The detective got a new warrant. Number 11, the defendant's iPhone, it was granted in part from the date of the homicide up to February 13th. So we obviously kept anything that was backed up to that phone, including the pin drop information, some notes, some text messages in reference to gang activity. But what we also was suppressed were some of the notes and text messages from the past relating to
They got the
gang
whole crew up
activity.
that bitch today. They trying to get that boy home.
There we go. Number 12, the Google accounts. There were 2 accounts. We lost everything prior to the homicide was suppressed. That includes gang-related information as well as the gang Bible that was recovered from his account. And at number 13, which is what Ms. Collins was checking, the YNW booking. I actually didn't know offhand what was actually suppressed from that, but I believe it's more gang-related stuff. So effectively what was suppressed was a lot of the stuff the state would be using for aggravators.
The cell site location information
Remains in.
from October 26, 2018. None of that is.
Correct. And that's my summary. They disagree because I was trying to prepare this for today's hearing. I didn't have the time to go through every piece of evidence.
I think it was the same from what I said, but just to go a step further so the court understands, I agree with what the state had proffered as far as what's suppressed. Going to what specific witnesses testified to what we agreed was suppressed. You'd be looking at the majority of the testimony from Gannibal would be out. He testified to a lot of the photographs and Mr. Newman's phones that predated, as Mr. Ferguson said, the bookings, the YNW
man. You know it is.
Most
When you lock
of
people
what
up, you lock up the whole family.
testified to.
Especially
The
somebody
second
of
witness
importance.
would have testified to
They've been in
certain
jail just like he's been in
messages,
jail.
me with Mariah Hamilton, Detective Mark Moretti testified to a substantial amount of text messages that would now be suppressed. So I believe he said close to half a day where he just read text messages off of the screen. Most of that.
Yeah, you're right. I agree.
How about the
Like, yo, to have this man locked up for 7 years is crazy. Especially after the first case was a hung jury. Like, they should have gave him a bail right after that. Because at that point, he was locked up for what? 3, 4 years? 5 years, maybe? When Brian W. Melly trial was? 2 years ago? Like, god damn, bro. Like, this should be illegal, man. Well, it is illegal. I just don't know how they're getting away with it. Florida just doing their own shit.
Remain, and as far as his phone is concerned, it was granted in part from the date of the homicide to February 13th remains in.
So state,
Yeah, I
any
see.
evidence, witnesses, or testimony you want to present, or is it just your argument?
No, Judge, it's just argument. We're just relying on the trial transcript that the court has reviewed.
Your Honor, may I dismiss Dr. Holmes? She's not going to testify. She's not.
Okay, so the record is clear on this, but I'll put it in the written order also. I agree with
Hit the like button. Y'all only got 29 likes.
position. I
Get to
have not
50.
considered anything that was introduced as evidence in the prior trial that has been since subject to Judge Murphy's suppression motion. So I will not consider it as though we're not, as it's been articulated to me today by the lawyer. So, defense, I'll let you give me the, well, state, let me let you do it first. You're the ones who can keep up. So,
Are you looking for the most affordable?
Yeah, like they doing Melly wrong, man. Even with this bail hearing, like, how long it's gonna take for you to make a decision? You should already had a decision coming in this bitch. Like, it's only one right decision to make. Like, yo, the man been locked up for over 2,000 days. Like, it shouldn't be this hard. Like Sunday Best said, it shouldn't be this difficult, man. The man deserves a bond, man.
as to whether the proof is evident, the presumption is great. And even if I wasn't to find that, your argument as to whether I should or should not exercise my discretion to give Mr. Bennings go ahead.
Certainly, Judge, and that's the case law provided in the court. There's actually a presumption of correctness as to Judge Murphy's order, that there was proof evident presumption rate. So really what the court is considering now is just effectively has that suppressed evidence that the court is now considering changed the state's position where proof evident is no longer present. We believe that proof evidence still remains strongly present because, as the court was noting, all the information from the day of the homicide remains. So the vast majority of the evidence that was introduced at the previous trial remains available to the state. What the state effectively lost to summarize were a lot of the enhancers that were used, such as the gang activity, some of the information that goes to motive. But for the day of the homicide, the ballistics that shows that the shots were fired from inside the vehicle, the fact that Mr. Henry lied about the events, which was corroborated by the locations that were determined where the shooting actually took place, the shell casings that were recovered, the fact that the defendant's phone was traveling with the two deceased in this case along with them and then separated prior to Mr. Henry going to the hospital. The admission on Twitter that the defendant made where he said, "I did that." All that stuff that relates to the homicide, to the direct evidence for the guilt portion remains in evidence. So effectively, nothing has really effectively changed other than some of the arguments that the state can present to the jury in terms of both aggravators and motive.
So before I hear the defense's argument, based on the written pleadings, I suspect they're going to get up and tell me that since the jury didn't find him guilty of these, that's beyond a reasonable doubt. We were able to do that to the jury. So you're now asking me to find a higher standard that is proof evidence presumption grade. So give me a response to that.
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to cut that.
No, that's bullshit. See? There you go. Yo, 3 jurors found him not guilty. You know what I mean? There they go lying and misleading again. It was 1 juror at first, and she was able to flip 2 more. It was 3 jurors that found him not guilty, man. You see how quick the defense like, hold the fuck up. There you go lie this shit.
The jury didn't find him guilty.
Yo, we don't know the facts, man. How you gonna say he deserved nothing but jail? He ain't even found guilty. He already been in jail. Like, how much more jail do you think he deserved? At this point, they can find him guilty and give him time served. Like, the man been locked up there in there 7 years, man. See, that's that bullshit I be talking about. People only care when it happened to one of their family members. If this was your motherfucking cousin or brother, you wouldn't be saying that shit. You wouldn't be sitting there saying that like, dang, yo, they done had my man or my brother locked up for 7 years. He ain't even found guilty yet. Yo, that's just bogus.
That's beyond a reasonable doubt. We were able to do that to the jury, so you're now asking me to find a higher standard that is proof evidence presumption of grade, so you have any response to that?
My response would be is that it was a hung jury, and my understanding is that 11 of the jurors were ready to contest.
I have no idea what that is.
That it was a hung jury, but we don't know what their decision was.
It was, Judge, I have to object to the characterization that we don't know. It was mistried because they couldn't unanimously decide.
Now, you don't know what they do.
By which somebody is found guilty or innocent. So,
Yo, y'all be tripping me out, yo. This is not, this is a real channel, bro. Like, I don't know, you must be new over here. Yo, but people die every day. America kills people often. Like, yo, we ain't gonna do that, man. Yo, some of these motherfuckers be crossing the line. I mean, you just gotta take accountability when it's time. But the system is supposed to run fairly. The system shouldn't have had, like, this ain't motherfucking the Middle East. The United States justice system should not have a person in jail for 7 fucking years fighting the case. Oh, so you don't got no point. You just talking. Yeah, I ain't even replying to you no more. Thought you had sense.
You're in this trial. I got it. Anything else? No. Okay. Defense, your argument as to why I shouldn't find proof evidence presumption grade, even if I did, your argument.
Exactly, Billy.
Whether I should never.
You can't not talking like that.
And set some form of bond or pretrial release, and if I decided to do that,
can't live in the real world because this is not how the system. This is not normal for you to say you live in the real world. It is not normal to be fighting a fucking case for 7 years. There's nothing normal about this. This is very abnormal.
for the purposes of the proof evidence presumption grade, I have some factors. I know Ms. Liberty has a couple. If I could, Judge, I believe that the rulings by Judge Murphy, that starting with the testimony of Michelle Boutros.
I don't reply to trolls. And you probably not even black. So I care left what the fuck you say for real.
Judge Murphy ordered the state that when she testifies, they cannot cross-examine her in any further proceedings. The state appealed it on a motion, on an appeal, a writ of some sort, I forgot which one.
I ain't talking about you, Jacob.
I attached it to my supplement. The fourth denied their seeking relief on that issue. So I believe that Ms. Boutros, who witnessed Mr. Moretti, the lead case agent in this case, suborned perjury, will come in with no cross-examination in the trial. And I believe the evidence of Detective Moretti suborning perjury in this case is another factor Your Honor should consider, because that didn't exist in the other trial. And it has occurred after the fact, and it's been ruled on by Judge Murphy that Ms. Boutros is going to testify unchallenged by the state in the next trial. and I think that's something Your Honor can consider. There's transcripts of her testimony and what she saw and what you already did, and I think that's another factor Your Honor should consider. I believe, and there's something else that came up. You know, Judge, we got, on the day of discovery cutoff, was it Friday? April 30th. April 30th, it was 5-6 days ago. A new set of warrants and affidavits authored by murd3r that were done a year and a half ago.
You see what I'm saying?
Judge Murphy.
Look at this shit, man. This is the shit I'm talking about. They just got warrants the other day that was done a year and a half ago. Like, come on, yo. Like, this is bogus, man. This is a bogus prosecution. A bogus prosecution. How the fuck do you do that? How do you, and this is the second time they did that. Remember in the last hearing, they said he did it to him, but they did it another time. Yo, they keep releasing old evidence at deadlines. Like they're trying to handicap the defense, man. They've been playing dirty the whole fucking trial. It's crazy because the last prosecution got kicked off the case for playing dirty, and these motherfuckers come on and do the same shit.
Suppressed by this order for the same records that were stayed on appeal, and in those affidavits that he presented to various judges, mostly Judge Bober, nowhere did murd3r ever state that these issues were on appeal, that there was a stay, that they're asking for an expanded amount of records for the same social media and the same phones.
Like trolling. He's probably racist.
And we found out about it a year and a half later, just the other day. We couldn't prepare defenses up until then. And Your Honor keeps reminding us we have this trial date. And all of a sudden, we get all of this other
What the fuck is unsentenced?
results of a search warrant that was signed by a judge who didn't even know about the appeal.
Is that even a word? It's unsentenced the
So
word?
all of that is additional, and we're going to do a motion on prosecutorial bad faith, prosecutorial misconduct, police misconduct. We have to add all this stuff to it because it's new stuff that we just learned about less than a couple of days ago. But I think that's something that Your Honor should
Yeah, the man been on lockup for 4 years. The man been on lockup for a ticket that he beat for 4 years. Like, yo, like you see, he ain't gained no motherfucking weight. Maybe the same. How you be locked up 7 years and go in the same size and be same size you was when you went in that bitch? He fuck around ain't even eating properly. Like, yo, they doing this boy bad, man, because they don't got no case, or they mad that they lost the case.
220 says.
Or didn't get a conviction. I mean,
Obligation for discovery. They sought this information a year and a half ago in March of 2024, however that adds up. And they've had it since, and we don't get it until 5 days ago.
listen to this shit.
This is obstruction. This is
Listen to this shit, man. Like, yo, this is dirt. Yo, this shit is fucking wrong, man. Somebody's Supreme Court need to step in and end this shit. When niggas talking about YNW, Young Thug, man, fuck no. Melly getting treated worse than everybody right now.
That's something that Your Honor should consider. But what are we doing here when the 3.220 says they have an ongoing obligation for discovery? They sought this information a year and a half ago in March of 2024, however that adds up. And they've had it since, and we don't get it until 5 days ago. This is obstruction. This is
pretty much
unethical. This is absolutely not professional. And this is and the kind of thing that we're facing from this state attorney's office on an everyday basis. Every day. And I believe that the sub-issues there of forum shopping to go to other judges who don't have the institutional memory of this case is about. And Judge Murphy was still there back when they sought these warrants. So did they advise Judge Murphy that we're going to go do an end around advised the fourth that they're going to do an end around and seek the same and expanded amounts of information from those cell phones. When the judge said,
I'm sure he is going to sue him when it's all said and done. I was talking about that yesterday, a couple days, whatever I was talking about.
Results of the search warrant. So it's under suppression. They're telling another judge, go in there to try to get the same information, but broadly, so they can try to fix a warrant by not telling anybody they're doing it. So we're going to get to it at some point. But I think on a proof evidence presumption grade standard, it's another thing that Your Honor should consider. At the time of the first trial, the predecessor prosecutor, Ms. Bradley, hadn't filed 3 or 4 different Brady notices for evidence that they suppressed and didn't tell us about on the first trial.
Jesus Christ, this thing get worse and worse.
And Judge Murphy kicked her out of the courtroom, and that's why these people are here now, because she is a possible witness, because she filed 4 different Brady notices to us. They were all different. So that's something I believe Your Honor can consider, because that happened after the trial.
No, shit, he's saying a whole lot. What you mean? Shit, he said a whole lot. He's speaking on how the last prosecution been playing dirty the whole trial, saying this is why Melly deserves a bail. He's speaking on a dirty prosecution and then withholding evidence. Shit, he's saying a whole bunch. No. It's kind of low. You probably can't hear him that clear, but he's saying a lot. He's speaking, saying that Melly deserves a bail, yo, based off of all the factors that's going on, based off the prosecution playing dirty that whole time, withholding evidence and shit. The last prosecution got kicked off the case, and this prosecution for withholding evidence, and this prosecution doing the same thing.
Of the state's case against Mr. Beckles. And that's a factor I would submit respectfully that Your Honor.
The judge seemed like he on bullshit.
And I know I don't have them all, but I didn't mean to step on his Liberty's, argument, and I know he has some other stuff. If I may.
I want to buy your house.
The judge had been accepting enough of the damn defense been throwing at him.
Let me just summarize.
Judges don't like overruling other judges. So he's going to try to stay around the lines of what the last judge did. He got removed out the case as well. It's like they removed the whole shit from everybody.
I think the court did.
That's the top attorney right there.
The jury could reach a verdict, and the proof evidence presumption grade is a higher burden than reasonable doubt. The jury in that case did not know, it was hidden from us, that the lead detective attempted to suborn perjury, although the state knew about it prior to the trial. And that is why
more legal shit.
The lead prosecutor was removed from that case. Had the jury known that the lead detective was involved in criminal activity, I suggest that any reasonable person would totally discount his testimony completely, coupled with the fact that certain evidence was suppressed. What Mr. Benjamin was referring to was on April 30th from 3:30 to 7 o'clock at night, a little after 7 o'clock at night, we received 5 search warrants that are in my hand.
That's crazy.
They were all prepared, I believe, by Detective Moretti. They were all signed by Judge Boger. They were all signed, I believe, over a year ago that we never received until April 30th.
What the fuck, that was last week? That wasn't even a week. What the fuck that was? Last week.
Judge Murphy had suppressed portions of the items that they are now seeking. Nowhere in these warrants does it indicate that there was evidence that the affiant was supporting perjury. Nowhere in the fact does it explain why the state went to a different judge, because Judge Murphy was still sitting at the time,
They must retire.
and decided to go to a completely different judge, not disclosing any of these facts. Because I question whether or not had Judge Glover or any judge known this, they would have taken these 5 warrants and said, go back to the original judge.
What's up, Jay?
And I think that is something that the court
That is
should
true, though.
and must.
I just told you judges don't like overruling over judges. And he right about that. They took that shit right back to the original judge.
Ask. And it's interesting to note that on these warrants, there is in the left-hand, bottom left-hand corner, despite the fact that the warrants were signed in 24, an indication that says on one particular warrant, REV-AB 1124, which I suggest must mean revised by Assistant State Attorney with the initials AB on 1124, yet they give it to us over a year and a half ago. And may I tender what I'm referring to?
Well, I didn't limit anyone in any way. I asked you 3 times, do you have any evidence showing to present? You all said no, and now you're making arguments based on things that are not in evidence, and I have no idea what it is. So.
Fair enough. Do you have any objection to moving what you gave us April 30th?
Sir, you don't have to ask him.
Oh,
This is the evidence you're hearing. Yes, me.
may I introduce these 5 warrants?
Are they marked? Let's mark them as a composite exhibit. How about that?
Yes. I'm sorry.
They held 5 warrants against for them people, man. That shit crazy.
Okay, well, that's getting done. We'll call that defense exhibit A, composite exhibit, for purposes of the Arthur Grant.
And I move them in there.
Do you have any objection?
Yes, Judge, just because, for the purposes of only this hearing, just because we're considering the trial testimony and the evidence that was previously introduced in suppression, I wasn't going to ask the court to consider these new warrants.
Over the state's objection, I will make them in evidence for the purposes of the Arthur Grant only. So if you want to call that defense composite exhibit. Yes, sir. Go ahead.
The reason Mr. Benjamin and I make reference to that is because this is a continuing
Told
thing
you.
that's going on with the state.
Told you. They've been doing it for 7 years.
Every other day we get something new.
They've been doing that shit for 7 years, man.
This case that appears was
Like, yo, I'm telling you, if Melly get found guilty, appeals court gonna have a field day with this trial. This shit gonna get tossed out so motherfucking fat. Yo, this case probably get tossed out by the appeals court before. If it's a gap in between sentencing, this case gonna get tossed, man. All the dirty tactics that, yeah, I'm sure they did so much illegal shit. All the dirty tactics that the state have pulled is all gonna be up for the appeals court to digest. And this case gonna get tossed out even if he do get found guilty. You know, it's a death penalty case, so you know they look at them with scrutiny.
A year, if not longer. And as you're looking at those, at the defendant's exhibit.
Yo, that's not a troll page, bro.
One, okay. I want you to know that if you look at the docket sheet, it took us 4 hours to organize the warrants because they were commingled. Warrant number 1 had pages from warrant number 2 or 3.
God
And
damn.
it literally took Mr. Benjamin's judicial assistant, right, promoter, 4 hours to commingle all those pages because originally they came in so convoluted. Because I printed out how they came in. As another game that the state is presenting on a case where our client is looking at the death penalty. This is no game. And they have a continuing obligation under Rule 3.22. Not to wait a year, not to wait a year and 4 months, but they have an obligation to turn it over in a reasonable period of time. And if the warrants were signed by Judge Boger on 3/24, I think it was, of 24, what's your excuse for not turning it over to us? It's the charges that he's facing in the murder case. First-degree murder, 2 counts of first-degree murder, and accessory after the fact for the co-defendant. I mean, I don't know what the game is. I don't know what we're playing, but it's pretty disgusting, I submit.
There was one other point before I said that. In the first trial, that wasn't surprising. Was a gentleman who took the stand who said that Mr. Evans got out of the car and went home and was no longer near the cell phone. That was in the first trial. That was something that the jury considered, which resulted in a hung jury. And that's something that I think is very important as we sit here today. And I'll shut up now.
But I tell y'all, the reason they couldn't find them guilty is because they had that the other car went to the house. Remember I said that originally. The reason Melly was found not guilty and the reason the state case is so hard to prove is because 2 cars left that fucking studio. And they can't say if Melly got out of that car and got into the other car. Everybody in the other car testified, said Melly was in this car. Everybody testified. Then it was shown proof that they share phones. So that phone evidence, it's about reasonable doubt. Yeah, people got to remember the answer death penalty case. So the jurors, they ain't trying to make no mistakes. You know what I mean? You talking about taking somebody's life, you got to sleep with that at night. You got to be able to live with your decision making. And the black lady on the jury saying what was going on because they was trying to find him guilty on a charge that wasn't even related to the case. They was ready to find Melly guilty of manslaughter with a deadly weapon. Though this is a first-degree murder case. That's it. It's either you find him guilty of first-degree murder or not guilty. All them lesser included, like, yo, they never presented arguments for that. So the juror that held out and convinced the other jurors did the right thing. But the ultimate reason why it was hard to find them guilty is because, yo, 5 people or 4 people testified, say, yo, Melly, we switched cars. They couldn't prove it. They couldn't prove they didn't switch cars. And then you see the other car going to the gate with a rack of people on there. And the guy that worked the gate couldn't say if Melly was in the car or not. It's reasonable doubt, man. He probably is. But appeals court going to overturn it. The only reason they're going to lose because the state going to keep doing dirty shit. They ain't going to lose because they got the evidence. If you do lose, it's going to be because the state is playing dirty and they're going to continue playing dirty and they're going to get away with it. But appeals court is going to overturn it. It's on my page, the video I did a while ago. We'll start in 1 minute.
So I'll try not to repeat.
No, this ain't no trial, it's a bail here.
But if you're reading that transcript, I'm sure you'll get through.
Nah, bro, we just don't do true. We don't. It's not a troll page.
Like, bring the person.
You want to go troll? Go over there with academics and one of them clowns. Like we had real conversations over here, man.
The testimony again of Mark already. Talking about the change in circumstances that we learned after the trial was over. After the hearing, the first hearing on the bond with Judge Murphy, we were finally advised about what had went on with Detective
I'm being honest.
already and Christy
What you
Bradley.
talking about? I ain't being
That
objective.
was
Being honest.
so important to us, not only the fact that the jury was not made aware of that, and they probably would not have
Do you not hear this shit? Is this shit legal? You don't hear the state objecting to these claims. Nobody's objected. The last prosecution got kicked off for playing dirty, and they playing dirty too. You must not know the court system, bro. If you say this shit, if you say getting a warrant, if you say a judge signs off on a warrant a year ago, while this man is incarcerated fighting for his life, death penalty, life is on the line. He can die. He could die here. If you say that it is legal to sign off on a warrant and then give it to the defense a year and a half later, then you don't know shit about the court system, my nigga. That's it. It don't get no more legal than that. They supposed to sign that bitch off and gave it to them immediately. Immediately. They should not, at 7 years in, they should not still be handing over discovery. The defense should have all the discovery and had their case prepared. But they just handed over discovery last week for a warrant that was signed off on last year. Ain't nothing legal about that, man.
Testimony. But his testimony.
If he's a white boy, they wouldn't even be doing none of this shit to him.
The testimony of Brendan Collins, the FBI agent. So when you read that testimony, you see Judge Murphy order that we redepose Brendan Collins for that simple reason. Brendan Collins had testified at that trial, which is in the CDRs, T-Mobile, the cell phone data is in. State had put on Brendan Collins, basically to introduce his CAPS reports. He had testified that Mr. Demon's phone, or the 9807 phone, which was left in the car, but you heard testimony from Adrian Davis at that trial that phone was left in that car. He testified that you could not, with precision, give a location on that phone. He went through the different trainings he had got from the different cell phone agencies. One of the things that he had spoken about was one of the data sheets in that T-Mobile report has a column that reads environment. FBI testified you cannot rely on that they do not rely on it for the simple reason that they don't know where they come up with the algorithms that go into that column. So when you look at that column, it shows somebody could be mobile, they could be outside. Bottom line, the experts, if you can't rely on it, they don't rely on it, FBI. Mark Moretti, same guy who asked an officer to lie for him, then got on the stand and impeached Brendan Collins by saying what? That you could look at the data from T-Mobile and tell that somebody was outside, inside, or walking. He then went on the stand to give his own interpretation of what those CDR records meant. His interpretation, again, conflicted that of the FBI agent. Mark Moretti's testimony, period. We were deprived of knowing that he had previously perjured himself. We were deprived of the fact knowing that lead prosecutor had asked him and basically covered that up. And there was a change of circumstances because that was not brought to anybody's attention when Judge Murphy had made his first ruling. And for the record, that first ruling that Judge Murphy had made, it wasn't an Arthur hearing, there was no testimony put on. I believe at the time the only testimony that was given to the court would have been over Zoom from the family's aunt or mother. Nonetheless, getting to most of my motion, Judge. There is a case out there, Norco, and what it tells us is Reeves versus Narco, 141 Southern 3rd. What it tells us is, even if the state meets its burden under Russell, and I'll get into Russell in a minute, the circuit court may exercise discretion to grant pre-trial release if the defendant can prove conditions of release, if the defendant can prove that his conditions conditions of release can effectively protect the public from the risk of physical harm, assure his presence at trial, and protect the integrity of the court. There are some other factors that we get from other cases talking about flight, is he a risk of flight? So going through that.
Yo, it's crazy, y'all. I can't believe people still don't think this boy deserves to be out. Go to trial in September. It's only gonna be a couple months. This is not old, y'all. There's nothing old about this. 6 hours ago. This was live 6 hours ago.
He would be proposing for Mr. Devins would be a minimal monetary bond, with the condition that the defendant would remain at his new residence. The defendant would not have possession of a firearm. The defendant would wear the standard pre-trial ankle monitor for GPS tracking. I did put on that witness list, I will not call him, was a member of the security company who we have engaged.
Yo, people should be outraged. Yo, if they can do this shit to Melly, they can do this shit to you. People should be outraged about this, y'all. And it ain't about him being guilty or not. It's about the fact that this man has been sitting in prison for 2,000 days and haven't been found guilty. Went to trial, got a hung jury. Still, I'm not in prison, but jail. Still sitting in jail, man. Pre-trial. Yo, I don't know how many people sat in pre-trial, but that is the worst thing in the world. Like, fuck that. At this point, send me to prison. At least you get more freedom. Pre-trial tight as a bitch. And he on lockup. Remember, on lockup for 4 years. Now, this is serious miscarriage of justice.
One, it was twofold, but I had asked for Mr. Devins would have a 24-hour security guard on his person. There would be then two other security guards on the property to basically secure the premises of the property of the house and the house. They would be reporting if there was any infractions of Mr. Devins. They would be reporting directly to myself, the rest of the legal team, the state attorney, and to the court. So you basically have your own deputy, paid deputy, with him. Mr. Devins is not a flight risk. He does not possess a passport. I don't even believe he has a driver's license at this time. We can assure his presence at trial. He's been here every hearing. He will be here every hearing. He would have a monitor on him. The court would know where he would be at. There would not be any concern, actually, with him not being at court because you know where he's at all the time. My proposal with the security on it, with the GPS tracking, basically house arrest, it would effectively prove conditions of release can protect the public from risk of physical harm.
Well, Merton have a long career. He's
Given
going to
the
get by
singular
every year.
event that Mr. Devins is being accused of, it was not like, and I was looking at the different case law when we're talking about danger to the community. Most of the times dealing with a drug dealer and you're in fear of him coming out and still dealing drugs to the community. That's not the issue here. Again, it was a singular event. If there was a concern for public safety, I think I would meet that concern when we would with our stipulation to the house arrest, the prohibition of firearms, and the ankle monitor. I think we could secure that there is no threat to the harm. I think the state's biggest argument today would be to assure the integrity of the courtroom, of the judiciary. And of course, they're going to bring up the witness tampering. that case was very convenient. It was filed while we were pending our last motion for bond, and it does affect the integrity. You recently heard
Came
our
on earlier,
motions.
about 5 hours ago. The rig go live again in a minute. Once they're live, start, we're gonna switch it over.
The only person my client has been accused of tampering with was Mariah Hamilton. However, going specifically to that statute, it would require Mariah Hamilton was actually summoned to a legal proceeding. That legal proceeding is defined by that statute. The only thing that would be applicable was Mr. Demon's trial. Court said it many times. The record is devoid of any proof that Mariah Hamilton was ever under a legal obligation to come to trial. She wasn't. That
Like I
is
said, yo,
the only basis.
people not gonna be satisfied till it's happening to one of their family members. Like people looking at this shit like, well, he did it. Yo, this is bad, man. 7 years, damn near in pre-trial. We was talking about yesterday all the rappers that was alive when Melly before Melly went to prison. Everybody was alive, man. Melly went to prison before murd3r got killed. King Von. Like, yo, this man been in jail. I keep saying prison. This man been in jail for a long ass time, man. This is unexcusable. And then when you factor that into the dirty games that the state is playing, like, yo, it's only right to let the man out. It's only right. Now, would the judge do that? I don't know, because I don't really trust, yo. He's saying like he's siding with the state on everything.
What the state will argue is that he's tampering with witnesses. There's been allegations he tampers with this person, he tampers with that person. But there's no proof of it. We deal with, and I was based off the previous motion not written by the state. Based off the true facts, there's not been any tampering. When we look at these cases, and it was interesting because with both the constitutional right to this bail, it does give that exception, except for people who are facing death penalty or capital crimes, lifetime crimes, right? And you go to the next provision that says, hey, if you appeal something, you automatically have that right, except if you're charged with a capital crime. So I did some research on that.
Yo,
The whole base.
when you're in jail, you still got your rights, real. There you go with the dumb shit. His right, he haven't been sentenced. His rights haven't been taken. When you're in jail, you still got some constitutional rights. He ain't been found guilty, bro. It's unconstitutional. That's what this is. Unconstitutional. Which means it's against American law. Fuck court law. This is against American law, man.
For it, because there was a case that came later, and my apologies, I didn't write down the site on it, but it goes on to explain that you would not have been given a right, i.e. the right to bail, and then a certain class of people denied bail under that same provision. And they go on further to explain in the history of it, is that initially when somebody was faced with a penalty of life in prison, they feared that that person would abscond or they would flee. Mr. Demons knew he was going to be charged with 2 counts of first-degree murder. At 19, he could have ran, could not did anything. He did the right thing, Judge, and he turned himself
Very
in.
dumb.
I believe February 13th, 2019. 6 years ago. So it's 6 years of his birthdays in that jail. The last 3 years that he's spent in
don't
that
play
jail,
real, just a troll, bro.
he has been deprived
You
of
say dumbass shit all the
basic
time.
human needs, basically. He's currently housed in a situation that's 23-1.
Counselor.
Look.
Lawyers will give evidence, so if you want to present some evidence, I read that in your tweets, but there's nothing in front of me about but his current conditions are in jail, so I can't consider it.
Okay,
That's crazy. You can't consider that.
so the conditions in the jail aren't good. He's been there 6 years, Judge. The Constitution says everybody
What I say?
gets the presumption of innocence.
Do I say violating the
6 years.
constitutional
We're going
right?
now past 6 years. He has substantial ties to the community. His mom,
Real? Your dumb ass.
his grandma, his sister, his brother, his friends, his grandpa. They're all here supporting him. The special conditions are there, and that's what we get out of the different case laws.
He been on that for 4 years, bro. He been on 23 and 1 for 4 years.
That's one thing. You go to the second.
Imagine man on 23 and 1 for 4 years for a ticket he beat. He beat the ticket. He beat the fucking ticket, man. Didn't even find him guilty. And he still got him on lockup.
There are special conditions.
His
that
mother's
we
still in the jail.
Put in place to protect three things. To make sure he's present here. To make sure there's no harm and the integrity of the judiciary. I don't have any evidence before you. We were precluded of putting my witness on. He has no risk of flight, though, Judge. I don't think there's anywhere in this world that Mr. Demons could go at this point without being known. There is no danger to the community. This was an insulated incident that he's being accused of. But again, I believe the special conditions that we put in place would protect the public from any risk of harm. They would also assure his presence at trial. And again, we would be protecting the integrity of the judiciary. And I believe we have met it. The state has not presented to us any
Real cool
reasons
with conforming to
or
the
any
to the
special
mistreatment.
conditions that would say
Yo,
he should
accept
not
mistreatment.
be eligible,
Ooh,
for a
victim.
bond. And I will also just point out that the whole purpose of bond is not to punish the defendant. It's to assure their presence at trial. That's the whole basis, is to make sure they're coming to court, make sure they're showing up to trial, and they're not absconding. I believe there is enough before this court that the court can safely rely that he's not a flight risk, he will be in court, and the community will be protected. Nothing further.
Oh shit. God damn it. He's gonna call me back. He's gonna call me back later. I didn't put my phone on. Fucking jail call. Fuck, he called me so late for, man. She just called me early this fucking morning.
Yes, Judge, just responding to the points that were raised. Just so the court's aware, we have not.
Let me see if they started yet. No, they ain't started yet.
We have not litigated yet. There is a pending motion to exclude the testimony of both Ms. Boudreaux and Ms. Bradley. It deals with a collateral matter, and we obviously believe that it's not going to be relevant to trial, but they keep raising the issue, or they repeatedly raise the issue, that Detective Moretti swore on perjury, except there's been no finding of that, and there's no evidence of that, and actually the evidence tends to the contrary. Judge Murphy found no Brady violation in regards to Ms. Bradley. There were no findings as Detective Moretti's testimony during the motions to suppress. And attached to the motion to exclude her testimony is the IA clearance letter for Detective Moretti, finding that he had done nothing wrong. So when they say that he's suborned perjury, there's no evidence supporting that other than their argument and the testimony of Ms. Boutros, which they say now is going to go unchallenged, except that's also not correct. While there is currently a court order saying she's not subject to cross by the state still has the ability to impeach witnesses. So she still is going to be subject to the same impeachment that she faced during the motion.
Man just called me that's locked up.
The motion to suppress.
I gotta call up to jail for him. To see why he ain't getting this program. See why the fuck they holding him up?
I'm sorry, Judge. That's
You gotta call me back though.
stating a fact is absolutely untrue.
It's not performing, yeah, I don't know why it keeps, like.
I'm responding to their arguments.
Out your client's family members, I'm sure she's telling me the truth, but that's not before me either, I have no idea, so, I mean, I did 10,000 bond hearings in regular division, family members would testify, here's our address, here's our finances, here's our ability to pay. You all don't do anything. Go ahead, Mr. Trippus, that's
So, just responding, that's all. Sorry,
The judge that got on the prosecution for playing dirty too. Now he definitely been siding with the prosecution more, but I didn't see hearings when he didn't got on them for playing dirty. So he know the shit that she's saying is facts. Like he look how he looking at him. Like man, I've been doing this case for about 2 years now. She ain't lying about every motherfucking thing.
in regards to the testimony of both Collins and Moretti.
What's up, Take Game? We
Brendan Collins
they going live in a
testifies
minute.
to cell tower location information, which does put the defendant near the crime scene as well as the hospital. Subsequently afterwards, as well as the following the path. What Detective Moretti testified to was the environmental data. As Ms. Liberty pointed out, the FBI will not rely upon that because they don't know how that is calculated. Does not mean, nonetheless, that Detective Moretti cannot testify to it because cell site location information does not require expert testimony, and he'd be subject to the same cross that he was in the first trial. I think that covers it as to the phase one arguments.
What's up, Lord?
As to phase two, if we court is going to consider exercise.
Hit the like button, y'all.
Obviously, there's two factors here. One is that the defendant charged with homicide. He's killed 2 people, so he's
Damn.
Allegedly.
What the fuck?
He's already established that he presents a danger to the community. But not only that, he attempted to tamper with witnesses while in custody. It's actually the reason Mr. Henry is back in custody because he did have a bond, and that bond was revoked. Had Mr. Devins been on bond, his bonds obviously would have been revoked and he'd be back in custody.
How the fuck you want to say
Because
that?
there is probable cause that a new crime was committed. But to say that there's, I'm not going to litigate the C4 motion, but to say there's no evidence is also not an accurate statement. There are videos, jail calls, kites, all were recovered that are part of the 23 case. So I don't think it's accurate to say that there's no evidence supporting the fact that he tampered or attempted to tamper with a witness. And finally, saying that there is nowhere that he can go that he's not known, that's not the concern. The concern is if he goes somewhere where he cannot be returned. As the court has repeatedly pointed out, Mr. Devins is charged with the death penalty. Many countries in the world will not extradite back
That's
to the
not what he
United
said.
States
He didn't say
if they're
suspected. He said he did kill 2 people. Like he made a fucking definitive statement. Like he even felt guilty of that.
death penalty here. So the risk of flight with him is actually greater because it is going to be much more difficult to recover him should he leave the jurisdiction.
May I respond, Judge?
Last word.
So, as to your comment, in light of my client's popularity, we opted not to put somebody on to give you the address of where he'd be living at. We were going to proper, I would give that in camera as far as where he would live at. He would be residing with his sister and with his brother. We'll give you the address. We would have the security detail. All of that can be given to you in camera. As far as the second amount, his record label would be, if there was a monetary bond in place, his record label is agreeing to put the monetary bond up for him. So the
Record label is
financials
coming through.
would be covered because it would be coming from this record label. He is actually duly employed. He has a recording contract. He would be able to work.
That nigga still under contract?
Have
God
a
damn.
source of income. and we'd have conditions in place to ensure. As far as what the state's arguing that they're afraid he would flee, I can't think we alleviate any concerns when I put security on him. It would be essentially a private cop monitoring him 24 hours a day and another individual monitoring the property. They would be reporting back to not only the defense team, but the state attorney and to the court if there is any issue. Again, the ankle monitor is being monitored. I have other clients on GPS, and I promise you, within minutes of them not being where they're supposed to be at, somebody is at their house checking on them. So to say that there is concern that Mr. Timmons, while being on house arrest and a GPS tracking monitor, had abscond to another country is basically ludicrous. It's an impossibility. It cannot happen. We have met the factors coming under those three different combined statutes. It's protecting the community, the integrity,
Real, you a wild ass nigga, Real.
Judiciary, and basically
Somebody must have
making sure
robbed
he
you
shows up
every
for
day
court.
of the week.
I believe there
How many times you got robbed, Real?
for the court to basically be able to
Let's say
rely on
something
the
from
fact
school.
that he meets those factors. The state has not raised any additional factors that would say, all right, he's not
Yeah, they got bullied, right? You fucking had to.
Okay, listen, I appreciate the time, effort, and preparation on both sides. I guess you're written as to both cases, bond pending therein, for the motion pending therein. Regarding the defense motion to strike notice of appearance and all other pleadings of victims, as well as the urgent motion for order to show cause against the office of the Broward State Attorney, Harold F. Pryor and John Phillips.
California's
The state's motion to
community, what it
prosecute
is.
from witness list and for protective order. I'll ask both sides, state, I'll ask you first, how about, June 4th, it's a Wednesday, June 4th.
The parties arguing those aren't going to be here, Judge. That's, Joel and,
Of course they're not right
office.
here.
We're not going to be arguing those particular motions, so I'll have to consult with them. We can do June 4th for now, but
Same thing that the last time.
I can't,
You can't do June 4th, okay.
I'll be gone until June 13th.
How about
Yeah, it's Melly case.
June 20th, that's a Friday. State, we're gonna check with your people, defense, June 20th?
we'll check with our office after this. Just let the court know. I won't be here that day, but I'm not arguing those anyway, just so the court's aware.
Defense, June 20th, 8:45?
Fine.
Yeah. Okay, so, this will go, we're gonna set all three of those motions, the defense motion to strike notice of appearance and all other pleadings of victims, the urgent motion for order to show cause against the office of Broward State Attorney Harold F. Pryor and John Phillips, Esquire, and the state's motion to remove prosecutor from defense witnesses and or for protective order. All three of those I will hear on June 20th at 8:45 a.m. This defendant's trial in both of his cases will remain as already set, September the 10th at 9 o'clock. State, anything else I can do for you regarding Mr. Devens today?
Not today, Judge. I believe we have a couple of future dates and statuses. That's it.
Yes, Judge, Mr. Klinger is good, June 20th at 8:45. The only thing is, I believe the motion for protective order is moved now, because that witness list was filed just for the purposes of the Arthur hearing.
Okay,
So,
well, if that's
we will
so,
need
y'all
to,
can come and
the
tell me
state will
that.
need to have that heard.
That's your plan. Okay.
No, it's set for today's hearing.
Defendant, anything else I can do for you today regarding Mr. Devens?
Other than I just don't understand what you just said.
That's what I don't understand what both sides say. Quite a lot of it. Anything else you want me to consider today?
No, sir.
Okay. All right, Ms. Wilcox, then we're recessed until 3:30? Okay, so Division of Appeal otherwise being recessed until 3:30 p.m.?
All right, so they should be back live. They should be back live. Long Crime Network got him. Yo, if they don't get no fucking bail, yo, that's just. Yeah, That'd just be crazy, man. Like, god damn, like, how wrong can you do a motherfucker in that bitch? Yeah, that was this morning. You're supposed to come back at 3:30. It's fucking 4 o'clock. What the fuck that shit coming on? What the fuck her dusty ass watching?
who he's apparently still under contract with, that they would be the ones to post his bond if he were granted one. Taking a look inside the courtroom today, you could see Melly's friends and family really took up every available seat in there. Melly's real name is Jamel Demons. He is charged with the murders of two friends back in October of 2018. His attorneys told the judge today that if he were offered a bond, he would go on house arrest, living with family, that he would wear an ankle monitor so that law enforcement could track him, and that he would even have 3 security guards on him 24/7 to protect him.
I don't know, y'all. Judge playing games. I don't understand. Like, it shouldn't even have been no delay in the decision. To be totally honest, like, what the fuck is the delay for? Like, yo, how long? You had this case for forever now. Shouldn't be no delay. You know what the right thing to do is, man? Free that man, man. Let the man fight this case from home, man. Like, his life is on the line. He only giving him what? See, go to court in September. Man, he only getting a few months. Yo, it's another bond hearing that happened while we waiting on Melly. The guy that ran this the police over that killed his son, he had a bond hearing today too. Check that out.
The industrial grade product you need.
This is an eye for an eye. I can't even say I'm mad at him, for real.
It's time to take a...
Because of my honest opinion, I can't say I'm mad at Joe, man. The police killed this son, man. He felt some type of way about it. Like, shit happens.
Mark them as the court's exhibit 1, and to maintain licensed broadcasting staff to fill out a form for filming and recording of these proceedings. And the only provisions that I would order the press that no...
You know, Lord, that's typically what they do, yo. Typically when they don't got a case, they just hold you. Like, I ain't never said motherfucker held for damn near 7 years, but I done say motherfuckers held for 4.5. You know what I mean? Well, in Maryland system, you can't do that shit no more because the feds didn't investigate Baltimore City Detention Center and realized that they was doing... Like, this shit they doing on the Melly is illegal, man. If they was to do an audit of them jails down there, yo, that shit had to stop.
Witness or victim who objects to being recorded, you can't record those persons, but I think you know that, right? So that would be the order, and thank you for filling those out. You wouldn't normally do it, but because of the nature of this case and the high public profile, this is what we're doing. Under the rules...
Did he trial live? But you can't go to court and did he trial?
Give orders.
Right, so let's fast forward to the main part.
No. Okay.
Look all on that damn show.
let's resume order. Can we have the defendant?
Yes.
And these niggas ain't gotta go to work. The fuck they gave them an off day? Like who's patrolling the streets? Yo, hold the fuck up. Yo, who's patrolling the streets in Cincinnati and Hamilton County with all these goddamn sheriffs in the courthouse? Ain't they supposed to be working? The fuck going on?
Thank you, everyone.
Fuck they gave a week off?
Thank you.
What's up, Jill? Fuck around, get real lawless out that bitch. You ain't hear about this, bro? This the police killed his son, and he came back and ran the police over the next day. I mean, it's not even the next day, a couple hours later, killed the police. I know you is.
Okay, so we're going to come back to the desk here. We're going to keep watching what's happening. But at the commotion, it sounded like the man who stood up there, it sounded like he said he was the brother of Rodney Hilton Jr. As you saw on the video there, police.
It is.
Okay, and are you aware of his reason for being at CIS?
Issue of bond or bail. You may be aware of that.
I am aware of that.
Who would like to proceed?
I'm proceeding, Your Honor.
Thank you. And would you please speak loud enough so that everyone can hear you?
Yes, Your Honor.
America do it all the time.
Yes, Your Honor.
Go ahead. Is it okay if he begins?
Judge, he has a burden.
Okay, thank you. Clear and convincing
That's true.
evidence.
Yes.
Thank you.
Your Honor, we will call our first witness, Officer Beebe. Where would you like Officer Beebe to stand, Your Honor?
If it's okay, you can stand right there. If it's okay with him.
Thank you.
Good morning, officer.
Good morning, Judge.
So we're going to swear him in.
Do you
I was like tired of
solemnly
the
swear or
police, man.
affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth? So help you God?
I do.
Thank you.
It's just a matter of time
Officer Beebe,
somebody
I
did
need you to
something like
state your
that.
name and spell your last name for the record.
Carl Beebe, B-E-E-B-E.
And Officer, where are you currently employed?
I'm employed as a police officer at the City of Cincinnati Police Department.
Okay, what is your current assignment?
Currently assigned as a detective in the homicide unit.
Okay, in that capacity, were you called upon to investigate a matter that involves the defendant Rodney Hinton?
I was.
Okay, is Mr. Hinton in the courtroom with us today?
For real?
He is.
Would you please?
Identification stipulated.
Thank you.
Thank you. And identification is one of the elements in this process. And Mr. Nelson, would you advise
He just
the
killed
court
a cop
what statute,
a couple hours later.
if any, that you were operating under this morning?
Yes, Your Honor, it's 2937.222. It's hearings on bail and grounds for denying such.
Thank you.
Okay.
Proceed.
How did you become involved in the investigation involving the defendant?
We were notified of a crash that occurred at 200 West Martin Luther King Drive, where a deputy was struck by a vehicle and at the time had serious injuries.
Okay, and is that location?
No, if you
Hamilton
write him,
County,
Jim,
State of
make sure you
Ohio,
write him,
City
go
of
see him.
Cincinnati?
It is.
Okay, and so where did you begin your investigation? At what point?
Myself and several other detectives, officers, and
Yeah, that's bogus.
investigators from a traffic unit went.
The fuck happened?
Which related to an incident that had occurred the day prior. His son
You might need
had
one.
been shot by a Cincinnati police officer.
Okay, and so was he there to, I guess, to meet
Get
with
your
the
mind
chief of
right.
police?
Live life on the edge a little
And
bit.
so on that date, at that time, did he view a video which depicted his son being shot and dying as a result of contact with a Cincinnati police officer?
Yes.
Okay. And then after he viewed that video, and if you know, approximately what time did he view that video?
Shortly after 9:30 that morning.
Okay. And after that, do you know where he went or what he did?
Yes. So he left that the parking lot, I believe, shortly after about 10:30.
Oh, so he viewed. So he viewed the video. I didn't know that. So after he viewed the video, that's what he said, man. Fuck these police. I'm ready to run one over. That's what happened. I didn't know that's what happened.
On witness statements, he went to
They
a
definitely
couple
need
of
7
different
days no better. They want some bullshit.
and then later returned.
I ain't gonna no goddamn
I
Nicky
believe
Truth.
about
Nicky Truth need to come over here.
12:40 he returned to our lot.
Okay. Were you able to speak to the people or some of the people or family members that he was with when he was at CIS?
I was.
Did they describe his emotional state at that time?
Yes. They said that he was.
Yo, see, this is the thing, right? This, it was just a matter of time. Yo, it's only so much disrespect and mistreatment that people gonna take, yo. Like he probably been more than likely, probably been mistreated by the police in his own life. Yo, you can't keep poking people and pushing people and expect people not to react, man. You can't do that. I mean, like, yo, I'm not saying I agree with what he did, but I'm definitely saying I understand it. I definitely understand why he did it. I never been in that situation. I don't know what I would do in that situation. Then when you hear the police chief say we killed this son. So if y'all as a unit is taking blame for killing or taking accountability for killing his son, then y'all as a unit got to suffer the consequences if that's how he feel. Like that, I mean, that's just how I keep that shit real, man. She didn't say this officer killed this son. She said we killed this son. So we gotta pay. If y'all take it, if we all a team in this, then he can decide to go ahead and do whatever the fuck he want as long as he on that fucking team. Now, is he right? Who knows?
And they were concerned enough about his
Hey, Jay, how you a black woman talk about you people? Jay, you funny as shit. Hey, Jay, you gotta get yourself some black friends, man. You gotta get around some black people. Come to Baltimore, Jay. I got somebody for you, man. Take a flight to Baltimore, man. I'll put you on with somebody, man. They're gonna change your life, man.
That they did not want him driving.
I was fucking violation for that.
The first
Come
time
to
that he was
Baltimore.
there, when he
I got
left,
somebody for you.
he actually
Gonna get
left
you right.
with family members and not driving the car that he had driven to that location.
Okay. And do you recall it? What sort of car was he driving after he returned to pick up his car from CIS?
It was a black Ford Focus.
Okay. Approximately what time did he return to CIS to pick up his vehicle?
Straight up.
I believe it was approximately about 12:40 p.m.
Okay. Were you able to trace his progress from CIS to the point where he came into contact with Deputy Henderson?
We were.
Okay. And can you describe where he left, where he drove from CIS to the location where Deputy Henderson was struck?
Well, he after he came back to pick up the car, he actually left the parking lot, followed by some family members in another car, and then a few minutes later returned to the parking lot at CIS, drove through the parking lot, and then left the parking lot again. That was at approximately.
He was mad as a bitch. They killed his son, man.
Around 12.
Then that was his only child.
He left the lot the last time.
Okay.
And then from there, proceeded up to the Clifton neighborhood, where he was traveling northbound on Clifton Avenue, and then turned to travel eastbound on West Martin Luther King Drive.
Okay, so that's a right-hand turn from Clifton Avenue proceeding northbound on the MLK, is that correct?
From northbound on Clifton Avenue to eastbound.
Melly Bell.
And,
For people that's
where
trying
was
to have with
Deputy
Melly Bell is not going to be determined yet. I don't know why it takes a week to make a decision. I think he's just trying to prolong it, but that's fucked up. I'd have been pissed, y'all. Yo, one of the worst things you can do, y'all, is go to court for a bail hearing and they deny your shit or postpone your shit. Man, I'd be so motherfucking mad. Bitch, you could have left me in the jail for all that. Like, y'all could have did all this shit without me. Like, yo, don't bring me up this bitch. Had me sit up this bitch for 4 hours, then send me back with no results. Man, that shit pisses me off, man. He did that shit to me before. I was mad as a bitch. Had me riding all the way from Jessup to motherfucking Baltimore County, Towson, just to deny my fucking sentence reduction. Like, yo, you could have did this in writing. You feel me? Like, yo, you could I would have been completely fired, but you doing this in writing. I did not have to come up here for that.
Henderson working on this day?
He was working from the intersection of Clifton Avenue and Martin Luther King
So
Drive.
the real, I got
He
the
was
real
working
here,
one
T real,
intersection to
not
the-
real clips.
To the east, where there's a traffic light there.
Okay.
At 200 West Martin Luther King Drive.
And what was he doing at that traffic light? What were his duties?
He was engaged in traffic control duties. There is a traffic signal box that's mounted on a metal pole at the corner of the intersection. In that box is a cord with a button on the end of the cord. That button can be used to cycle the light. There were graduations at the University of Cincinnati that day, and so there was a large volume of traffic in the area. And so he was controlling traffic and assisting pedestrians crossing the roadway.
And was he in a sheriff's deputy uniform at that time?
He was. He was wearing a sheriff's deputy uniform, wear a hat, and a fluorescent vest, traffic vest.
Okay. And his employment history involves being a deputy with the Hamilton County Sheriff's Department. Is that correct?
That is correct.
Okay. And so he was performing duties as a police officer directing traffic on that day. Is that correct?
That's correct.
Okay. Let's see. Were you able to retrieve any video from any stationary cameras or mobile cameras?
We were.
Okay. And please describe the cameras that you were able to get footage from.
We had one camera that was a fixed camera. That camera captured them turning from Clifton Avenue onto West Martin Luther King Drive. It was pointed in that direction at the time the incident actually occurred. It was redirected to the scene after the deputy was struck. We also had the opportunity to view camera from a vehicle that was in traffic on West Martin Luther King Drive, approaching the intersection where the deputy was struck, and it did capture the incident.
Okay. And were you also able to speak to people who were in cars that were within one car length away from the defendant?
Yes.
Okay. So your information is obtained from a static video camera, actually it's a moving video camera that was moved to the position after the accident, a video camera that was actually in a bus that was actually on MLK that depicts the incident, and testimony from multiple witnesses who were there. Is that correct?
That's correct.
Okay. When you pick up the defendant turning eastbound onto MLK, please describe his path of travel.
So initially he was in one of the lanes on the right side. The traffic was slow moving, stop and go traffic. At some point, based on witness testimony, they moved into the left straight lane. And then a short time later, pulled into the sort of the painted median. It's not a raised median, but a painted median between the two. Eventually, that turns into a left turn lane to go into Burnett Woods.
All right. So at that next intersection where Officer Henderson is standing and running traffic, you can take a left to go into Burnett Woods and a right to get to UC where the graduation was happening. Is that correct?
That's correct.
Okay. And describe the defendant's path of travel after he pulls into the left turn lane, the one that is used to turn into Burnett Woods.
So based on witness statements, he pulled into that center lane, the median, turns into the turn lane, pulled into there and stopped. There were no other cars in front of him at that point, no obstructions.
Let me ask you a question. When he stopped, was he at the intersection or did he stop short of the intersection?
No, he was well short of the intersection at that point.
Okay. And was traffic moving eastbound while he was sitting there?
No, traffic was stopped.
Okay. But was there room ahead of him for him to pull up to the intersection should he have wanted to turn left?
Correct. There were no vehicles in front of him.
Okay. At that intersection, are there plastic, I guess, for lack of a better word, sticks that are actually in the ground and the pavement to ensure that people travel in the proper lane of travel?
There are further up closer to the intersection, yes.
But he was not up to that point at that time. Would that be correct?
Correct. Not at the point that he stopped.
Okay. Tell me what he did after he stopped.
So based on witness statements as well as the video, the vehicle accelerated quickly, proceeded eastbound, crossed into the oncoming lanes of traffic when there was no longer traffic to obstruct his travel. Crossed into the oncoming lanes of traffic, went to the left of those little stanchions that are in the middle of the roadway, into the oncoming lanes, through the intersection, directly at where Deputy Henderson was standing, and struck Deputy Henderson and the metal utility pole on the northeast corner of the intersection.
Okay. Were there any evidence of skid marks?
No, there were no indications at any point that he tried to brake, stop, or otherwise avoid Deputy Henderson.
And is that the conclusion that our accident reconstructionists have come to at this point?
At this time, yes.
Okay. And does it appear from your review of the video that he headed straight for Deputy Henderson?
Yes.
Okay. And did any of the multiple witnesses that you spoke to and the people that were in the vehicles that were surrounding him, the people that were on scene, did anyone indicate that any attempt to slow down or deviate his path straight to Deputy Henderson?
No, everybody said that he accelerated and was traveling at a high rate of speed, all the way up until the time that he struck Deputy Henderson.
Okay. And when he struck Deputy Henderson, was the deputy injured?
Yes.
Okay. And what happened after he struck Deputy Henderson?
Deputy Henderson was launched several feet through the air. He came to rest in a turn lane several feet from where the collision occurred.
Okay. And what happened in the immediate aftermath after he struck Deputy Henderson? Where was the defendant? Who was on scene? What happened?
The defendant was located inside the Ford Focus. There were some other officers that arrived almost immediately, as well as
Okay, as we try to get audio back in the courtroom there, some
attempted life-saving measures.
Oh, we got the audio back. Let's go back inside the court.
Succumbed to his injuries and was pronounced deceased a couple hours later.
And in addition to the people that you spoke to that were on the scene and the vehicles that were surrounded, did homicide speak to other witnesses as well?
Yes.
Okay. And from your investigation and from speaking to those witnesses, what is your conclusion as to what happened on that day?
We believe, based on our investigation, the witnesses that we spoke to up to this point, that Hinton left our office and was traveling and came upon Deputy Hinton and made an intentional decision to drive directly at Deputy Hinton and strike him and kill him.
Okay. And based upon that investigation, did you decide to charge the defendant with aggravated murder?
We did, yes.
Okay. I don't have any further questions, Judge.
Mr. Bennett, you may cross-examine the witness if you like.
Judge, first of all, I would like to offer on behalf of the Hinton family and myself, prayers to the Hinton family, prayers to the family of Larry Henderson, the fallen deputy, and I thank the court for having a fair assembly in the courtroom today. With that, I'd like to ask you a few questions, not a lot. Okay. You said that Mr. Hinton left the police station around 12:30.
That man said, fuck you niggas.
CIS.
He initially left around 10.
That man left the police and said, fuck it. I'm on your ass. Killed my fucking boy. So see, the problem is, y'all, I don't think he had that gun in his hand. You really can't tell from that video. And we can't watch it because they copyright the bitch. But you really can't tell in that video if he had it in his hand or not. I think he dropped it. Let me show you what I'm talking about for people that's confused. I think he dropped it when he fell. Because I don't see why would you pick it back up. You already fell with the bitch.
He's got a gun. He's got a gun on your right. On your right.
In a matter of seconds. It all began with a stolen vehicle, a Kia from Edgewood, Kentucky. GPS tracking led the investigation here, a condo complex in East Bryce Hill.
He's got a gun. He's got a gun on your right. On your right.
In a matter of seconds. It all began with a stolen vehicle, a Kia.
To the officer, you're right. Yeah, but they took blame for it. They say we killed this son. So if we killed this son, then we got to suffer the consequences. Ain't that how it work in America? Don't America do that to the adversaries?
And left again.
And then returned a couple hours later, yes.
And you said that...
Ain't that the American way, or I'm tripping?
Saying that he appeared to be agitated.
Is that the American way, or I'm tripping? Don't we make other people pay for what other people do?
Upset and so forth, correct?
Yes.
And you don't know the source of that that agitation or that distraughtness, do you? If you know, you might not. I don't think you do, but you have to answer the question.
The source of the agitation?
Yes.
Well, I would assume it was because of the, I believe it was because of the video.
Yeah, you know they be doing that shit, real. You know they do that.
You know the mental history of Mr. Hinton?
No, I do not know detailed mental history.
Right. Do you know whether or not he's had any medically documented infirmities or conditions? Do you know that? You don't, do you?
No, I do not.
Okay. And then you also don't know his state of mind at the time of the incident. Near Vernon Woods.
I think he cool with going to jail.
You don't know.
See, that's the thing about him. I think he's completely fine with going to jail. Like, this is a man that's at peace with his decision making. You feel me? Like, he ain't worried. You think he worried about jail? That man is fine with going to jail. They killed this son, man. He is happy. That man ain't trying to beat this case. He good. However it go.
Based on the facts and circumstances surrounding it, I think we.
You think he
the evidence and the evidence, yes.
Yeah. Are you familiar with acts of someone that is not in their right mind when they commit a criminal act? If you know.
Can you clarify your question, please?
Are you familiar with the characteristics of acts
I'll
of...
object to that one.
I'll object to that? Okay. You don't know whether or not he was in his right mind at the time that he encountered Deputy Henderson on Martin Luther King Drive.
I think he cool with it.
You don't know that, do you?
Y'all ain't see how he walked in the courtroom? Y'all ain't see that video I did? Let's go back to the video. Then we want to go back there. Y'all ain't see how he walked past them police? That man is at peace. He ain't tripping about nothing, you heard me. Where the fuck that video at? He's at peace, y'all. Shit. Hey, y'all know how I am. Take accountability. I can't say nothing about it.
This all started yesterday morning. We're told plainclothes officers used GPS to track a stolen car down to a condo parking lot here in East Bryce Hill. Chief Terry Thigi says when uniformed police arrived, 4 people got out of the car and started running. One of them allegedly aimed his gun at officers. That's when a plainclothes officer shot and killed him. Police later tracked down and took 2 other people that were in that car into custody.
We have just learned the names of the 2 people now facing charges after a chase that ended with a deadly police shooting in East Bryce Hill.
Austin Durrell and DeAnthony Bullocks are due in court this morning. Both men are accused of receiving stolen property and obstructing official business. CBD tells us they ran from officers investigating a stolen car at a condo on Warsaw Avenue yesterday. Another suspect was shot after officers say he pointed a gun at them. A 4th person is
He didn't
still
point a
on the
gun
run.
at him, though.
Now,
He lied.
Kroger says he spoke to the officer who fired the deadly shot during that chase.
You don't have time to think in this situation. It's nothing more than a reaction because you want to save yourself. Anytime something like this happens, there's a range of emotions that they go through. But I have no doubt that the officer will come through this okay.
Hit by a car while directing traffic. Thanks for joining us at 4 o'clock. I'm Ashley Kirkland.
And good evening to you. I'm Sheree Colella.
We are now learning that that deputy is in
critical
condition. A few officers telling me, quote, extremely critical condition. All of this unfolding.
That's all I be saying. Yo, know what you doing. If you want to participate in this type of shit, stand on it. Don't start bitching up. And he's standing on it, so I gotta. You can't do nothing but respect it.
Go along Martin Luther King Drive and Burnett Woods.
You can't do nothing but respect it.
WLWT News Size Brian Hamrick. Brian, what can you tell us about this crash?
Yeah, Sheree, well, that's exactly where we are. We right at that intersection of MLK and Burnett Woods. Let me show you exactly what's happening. There's a pretty good vantage point from here. Really, the only place where you can see exactly what's happening here. You can see this vehicle. This is a dark colored vehicle. This is where all the activity has been. They have not sent anyone up to tell us exactly what is happening here. So I'm going to show you what's happening, at least with the investigation part of it. See that vehicle? The front of it appears to be smashed into this pole right here at MLK and Burnett Woods. It was a very powerful impact. The tire is underneath of it. The side of that vehicle is smashed in. They've now started putting evidence markers on the side of that vehicle. Officers have been out here all day long.
People die by being guilty by association all the time. Yo, the officer said we did it. That's what she said. She said we did it. That was her words. We did it. So if we did it, then we got to face the consequences for it. You know, that's how I look at it. What a video when he walked past the police.
Safe, and I asked that because he was transferred, as I understand it, to Clermont County yesterday. That's correct. On my order. That's correct. And will he be returned to Clermont County until Tuesday? That's all I understand. And you have a safe environment for him there in Clermont County? Yes, sir. You'll return him on Tuesday, May the 6th at 8:30 a.m.
Look, check him out. He's cool. Yo, ain't tripping. Yo, ain't tripping. You heard me. He know exactly what he did, and he know the consequences he facing. You gotta respect him, and I mean, regardless if you think what he did was the right thing or not, you gotta respect his mind for standing on it. He ain't crying. Yeah, but that's water under the bridge, just like this is.
Okay, so once again, still having some audio issues in the courtroom, but Clyde Bennett on cross-examination. Let's go back inside.
At the time he committed this offense, it's stated in the statute.
You might need to get a better lawyer, though.
2937.22. I believe the C3, the character, physical, and mental condition of the defendant or the accused. That's an issue.
It's a crime of passion.
I believe that the witness indicated that his opinion was that the act was intentional.
Right. And in making that opinion about whether or not it's intentional, you need to know the mindset or the mens rea of the person that you're
For real though, Lord, you ain't lying.
to do this.
You can say that about anybody, anything, any
With
situation.
respect to your bond attorney.
I'll sustain the objection.
Yeah, we don't fuck with our Sharpton over here.
Clarification. It's not the time of the event, it's the time of the history of the accused. So actual intent at the time of this offense has no bearing upon this court's decision.
I'm not saying that my client didn't try to intend to do this. That's not my position. One more question. You don't know his mindset at the time of the act, do you? Yes or no?
Like I stated previously, with the facts and circumstances surrounding it, and him driving up until that point, and all the circumstances that surround
It's a yes or no question.
him leaving our office, and from talking to witnesses, he was emotionally distraught, and they were concerned about him driving, and they were concerned about his...
Look, told you he wasn't even paying attention. He did it by mistake. I told y'all. He was on the phone. He was texting and driving. Yo, this was not on purpose. He was texting at the time of the accident, y'all. He started driving fast. You know, he was emotionally distraught. Whoops. God damn, he ran over the cop. Shit. He ain't mean it. He ain't mean it, man. Man, they need to lessen his charges to leave an accident that caused bodily harm or injury. I mean, 5 years.
No further questions, Judge.
Mr. Bennett, thank you for your questioning. Does the state have any further witnesses?
No further witnesses.
Please.
No.
Mr. Bennett, under the statute,
I don't think he cared,
the
bro.
defendant has a right to speak if he wishes at this hearing.
Yo, for one, the police lied. The police lied and said at some point the gun at him. You can see clear as day the son's back is turned. He ain't pointing no gun at him. I think he dropped the gun. See, if we can watch the video without them fucking copyrighting the bitch, we can't watch the video because they're going to copyright it. Then I'm going to take my whole video down.
All right, Judge, I'm going to speak on behalf of Mr. Hinton.
Thank you, but you do recognize that under the statute that the court must allow the defendant to make a statement at this hearing if he wishes.
That is my understanding, and that's a right I don't wish to exercise on behalf of my client. I don't.
No, bro, they intentionally lied.
Is that right, Mr. Hinton?
No, Rick didn't do that. That was an intentional lie. He said he pointed the gun at him. You know if the gun was pointed at you when you looking at a person. No, that was intentional.
All right, thank you so much. State have any further witnesses?
No further witnesses, Your Honor.
All right, shall we move to argument?
Yes, Your Honor.
All right, so the position of the state is that, what's the state's position as to bond?
Judge, as to bond, and in closing, what I would say is that pursuant to 2937-222,
They found a token
we have
black
shown
man.
proof that it is evident that the defendant committed the crime. We have an investigation that includes information from multiple witnesses.
They're probably like, yo, we gotta get our only black prosecutor. This is all you, man. You gotta. You know, see, that's why when you join these entities, you become an enemy of the people. Like you can't work some of these jobs, yo, and then claim your allegiance to the community, yo. When I wonder how many black prosecutors they got in office. It might be like 3 of them niggas.
Were within 1 car length away or less from the defendant, and 2 videos depicting his path of travel, one of which shows the collision. This evidence and testimony suggests that people were worried about him when he left the police department, having just viewed a video of the death of the son. He was observed by witnesses, and
he ain't doing it on purpose, y'all. I'm standing on it. He was distraught. He wasn't paying attention. He started off going 30. Next thing you know, he was at 60. Next thing you know, he had 80, but he wasn't paying attention though because his mind was somewhere else and made a mistake. You know, shit happens like that sometimes, man. It's a dirty world. You know, sorry somebody had to lose their life behind it, but it's just, you know, it's just an unfortunate situation.
Video cameras as he operated his vehicle and drove towards where the police officer was. The evidence suggests that he proceeded eastbound on MLK until Deputy Henderson came into his view. The evidence then shows that he deviated from his eastbound course, pulled into the leftmost turn lane and waited. And before he...
Come on here with the video, man. That's the most important testimony.
Okay, so yeah, we're having a little trouble back and forth, obviously being
I
there.
did that shit on purpose.
Demonstrates.
They did that on purpose, man. Important as that testimony was, they backed out of the shit.
Prior calculation, design, and premeditation in causing the death of Deputy Henderson, who was a law enforcement officer engaged in the course of his duties. Because of the extremely random nature of this attack, it renders an unpredictability for the defendant that cannot be accounted for.
They're gonna back out the most important testimony.
We have no way of preventing him from removing an EMG device, no matter what kind of bond you give him, and gaining access to another vehicle and doing this again. Defendant in his current state is a giant mental health question mark and is a clear and present danger and poses a substantial risk of physical harm to law enforcement officers and to the public, as evidenced by his conduct on the 2nd of May.
I don't think
there are no other alternative means or conditions of release that will adequately protect the public. The weight of the evidence, the nature and circumstances of the offense charged as being an offense of violence, the defendant's mental condition, and the nature and seriousness of his danger to police officers and others in the community strongly suggest that denying bond is both in the interest of the community and in the interest of the defendant. Additionally, Section 2937.222 provides a mechanism in which the Court of Common Pleas can review and modify your order should new evidence come to light if there is a change in circumstances, as that can affect bond. But at this point, Your Honor, we believe that we've met our burden pursuant to 2937.222 and ask that you deny the defendant bail.
What do you have from the state with respect to a personal history or criminal background of the defendant this morning?
Your Honor, the defendant...
And this is required as a review under the statute, Mr. Bennett.
Yes, it is.
Thank you.
So, Your Honor, in 2017, there was a domestic violence charge where the defendant pled guilty to disorderly conduct. In 2019, there was an assault conviction out of Hamilton County. And then I believe there was an assault conviction out of Middletown from 2023 and an aggravated menacing conviction out of Middletown from that same court. So that's his prior history.
Thank you. And what about any known community contacts that you're aware of?
I'm not sure what you mean by that, Your Honor.
His family background, do you know anything about that?
I don't know anything about that, Your Honor.
All right, thank you. Let me turn, have you finished your argument?
Yes, Your Honor.
Let me turn to Mr. Bennett. Mr. Bennett, anything as to bond or bail under the Constitution?
Judge, I'm going to address the factors that are set forth in the statute for no bond and also Criminal Rule 46. Before I do that, in summary, what I would like to do, I want to make certain that this young man is treated as a mentally ill person and not as a cop killer. I don't think he was a cop killer. I think he was not in his right mind. And I think he should be treated like any other mentally ill person that commits a crime under the auspices, control, and authority of a mental defect in a condition. That's what we have in this case.
Do you plan to file a request for a competency evaluation after this hearing?
Yes.
All right.
Yes.
This court is not empowered to do that today.
That's why I was going to ask for it.
If the matter is referred to the grand jury for consideration and further indictment, you may have the opportunity to make the request at that time.
No, they moved him. He not in Hamilton County. So he not in the same county where he killed the police at. He in a whole different jail.
I wasn't making a request at this time.
Yo, come on with the audio, man. What the fuck is they doing? They keep doing that every time they speak about something that matters. They back out the fucking part, the broadcast.
Thank you. Go ahead.
Mr. Hennon's 39 years.
Fucking Wi-Fi's. Broadcast.
Okay, we're still trying to get back into the courtroom. It's been going in and out, doing our best. A lot has come out over the last few minutes, but right now,
he lives in Middletown.
I think we have him back. Let's go back inside the courtroom.
He lives in Hamilton County.
All right, okay. All right, I thought
he has lived in Middletown in the past, but he lives in Hamilton County now.
For how long? Can you share that?
Several years.
All right, go ahead.
They keep cutting it out. Act like it's a
strong
mistake.
family ties. His family retained me. He lives with his significant other and his children. He does have limited contacts with crimes of violence.
How police off at one time.
Misdemeanors.
Fuck, I'm trying to figure out.
Other than that, he doesn't have a full criminal record and doesn't have a significant history of failure to appear. I think there's one failure to appear. I conducted my investigation and I couldn't find out where that one failure to appear came from. But what I agree with the state is that there is a giant mental health issue. And I would ask that whatever bond, whether it's a no bond or a monetary bond, I would...
Damn police officers sitting in that courtroom. I don't know if you get that from. I'm not even necessarily sure what they're talking with.
He's receiving no treatment in Claremont County, mentally or physically. I've got a problem with that. And I would ask the court to take that into consideration with respect to the judgment here or decision on bond. That's all I have at this point.
Thank you. Does the state have anything finally to say?
Judge, the only thing I would say is that I don't really have an objection to him getting mental health treatment in jail. That's fine. I mean, mental health treatment is good. But as far as what we need to show is, number one, the proof is evident, or the presumption is great that he committed the offense with which he is charged. We know that because we have video and witnesses who saw it. Number two, he poses a substantial risk of serious physical harm to persons or the public. And he...
Why don't you repeat that first paragraph again that you just read?
The proof is evident, or the presumption is great that the accused committed the offense to which he is charged.
Hold it. I will make a finding under revised code section 3927.222 by clear and convincing evidence that the crime was committed as you described, based on the information presented this morning. Next.
Next would be that he poses a substantial risk of serious physical harm to any person or to the community.
Mr. Bennett, you want to address that?
I think in light of his mindset at the time that this happened, I was physically present with the defendant over the weekend. I think he has mental issues. I think it's a long way of answering your question. I think the conduct in question is classic mental illness criminal conduct. It's always intentional, it's bold, it's conspicuous.
I don't know that...
That's a hallmark sign that somebody is not in their right frame of mind, no attempt to deceive, no attempt to hide what they did, because they think that what they're doing is right, and they think that what they're doing is right because they're not in their right frame of mind. They don't understand the lawfulness of their conduct. So yes, I'm agreeing with Mr.
I cannot recall either in experience or outside experience a case that I've ever seen like this.
Shit, what you mean? What's the difference? See how that be that boy? What's the difference between a motherfucker kill my homeboy and I go back and kill his, or vice versa? The United States, what's the motherfucking name? Shit, Bin Laden bombed the motherfucking Twin Towers. We came over there and killed his ass. What you mean? We see this all the time in the United States. This is par for the course. This is how the country runs. The country runs on revenge, and that's how it always been, and that's how it's gonna continue to be. This is the first time the police got the short end of the stick. This is one of the first times that a victim, because he was a victim of his son being murdered, took his anger and frustration out on the people that committed the crime. No, I ain't never say that. I ain't never saying no good cops out there. Yeah, but it's a union. I guarantee you have a police funeral. I bet they're gonna bring the flag out and do all the 21 gun salute and do all the shit that the police do when they die. Right? Is that not what they're gonna do? I'm pretty sure they is. They're gonna ride them through the city and do all the shit that the police do, right? So just don't give a fuck. You still part of that shit. That's like being an ex-gang member. You still was a part of the gang just because you're ex. Just because you ex now, down make it so you can't face consequences of the gang. Nah, fuck no. It's the same concept. Like people like to separate things when it's beneficial. No, we gonna keep it all the same. Everything I just mentioned was the same. Ain't no difference. But it don't fit the narrative, so they're gonna make it different. No, fuck no. We saying this a lot of times. This is how the country is ran. Is the country not ran on revenge? Do people not seek retribution? I don't get what they talking about.
Based upon the state's comments, I find it very difficult to figure out how there could be any decision based on what they said that would protect the public and the defendant under these circumstances. This is a most unusual case.
I don't disagree with you, Judge, with respect to the no bond.
Thank you so much. I believe that Mr. Bennett said that he agreed with the court with the issue relating.
Yo, they keep doing that shit. Yo, they doing that shit on purpose, man. They doing that shit on purpose. Anytime he ready to say something substantial, they cut the bitch out. You done watch him do that shit 4 times now. All the pivotal evidence or testimony, they cutting out, acting like they got camera issues.
Continue to be held at Cornwall County. Will be kept in a safe way.
Exactly,
that,
bro.
He will be watched over in a way that would not
Come on, baby. You know what it is.
Self-harm based upon what everybody has said today.
Judge, I don't want to. I don't want the court to misconstrue, or the public for that matter, my comments about his stay in Claremont County. Claremont County is doing a great job. I met with him this weekend. He was in a flak jacket. They're making certain that he doesn't harm himself or anyone else. I just want to make sure, add that component of mental treatment.
You understand that as an impartial jurist deciding these issues between the defendant and his rights and the state and its presentation, that the court's required to make these inquiries.
Yes, Your Honor.
All right. Based upon the officer of testimony of this Officer Beebe.
Yes, Judge.
And all the facts and circumstances surrounding his testimony this morning, the comments of the state, that there will be an order of remand with no bond. Please assure the safety of the defendant and any mental health treatment that can be granted. No bond, and we'll give, if the officers want to stay here, and the public, you're welcome to stay through the other hearings. Otherwise, if you were concerned about this issue, you may leave, and then we'll take just a 5-minute break. When you're ready. All right, let me finish this order.
May 12th.
5/12. Okay, thanks.
Yes.
No, insanity plea ain't gonna work. I mean, it's worth a try, but it ain't gonna work. It ain't gonna work. Worth a try though. Shit, why not? Like, I can't necessarily say he wrong, yo. Like, it's fucked up as it may sound. It's similar to like when a healthcare worker. Remember when Luigi killed the healthcare worker? He got a whole bunch of support in that, didn't he? People still support that shit. It wasn't it wasn't the CEO fault. But he killed his ass, man, because you guilty by association. 3 days ago. I ain't watching that. I can't say you're wrong, man. Nigga was upset. Killed his fucking son, man. I think that was his only child. Yo, some people feel like they can't live without their children, man. What happened to day 2? They ain't have day 2 of Diddy trial yet? We already covered that yesterday. We covered that yesterday. Let me tell y'all something too, right? I told y'all this yesterday when we talked about Diddy. Yeah, the reason they brought them other people's names up is not because they're going to be testifying. So, anybody? Oh, here goes day 2. What the fuck? They brought them names up to see who cares about entertainment and to what degree. And to what degree do you know about entertainment? I think that was News Now. What News Now? Hit that like button. Y'all get to 100 likes. What? 21 left. Here we go. Yeah, that's really all it is. So what? I mean, yeah, I just be trying to get people to understand, yo. Like this is the American way, man. They got people believing shit that's not true, and only rules apply to a certain level of people, a certain class of people. Hell no. If we living in lawlessness, say that. Let's be lawless. I mean, don't just have the rules apply when it's beneficial.
Members and associates of the Combs enterprise also assisted Combs in locating and contacting victims who attempted to flee his abuse. When employees witnesses Combs enterprise through a pattern of racketeering activity, the defendant agreed to, in and affecting interstate and foreign commerce, knowingly recruit and in the criminal indictment for this week's sex trafficking trial of Sean Diddy Combs.
They ain't giving no new news. They ain't giving no new news on Diddy. Yeah, so I was talking about Wallow earlier, right? Yo, look at this video, man. Wallow's a fucking character. I used to believe Wallow too, man. Now I think he a character. Like Umar Johnson or one of them niggas. 607 on. These characters. Look at this nigga, y'all. Y'all ready to trip off, y'all. Too bad for y'all. So clout chasing gets you shorty. No, we never tapped in on the Tyree Nichols trial either, y'all. We never tapped in on this trial. It was a woman prosecutor. I wonder how she did. Like she ain't a little bad either. We gotta tap in on this trial eventually. Appreciate it. Really want to see, at least want to watch closing arguments. And yo, this relationship is fake, y'all. This is not a real relationship. This some shit they doing for clout. She can't even, they was asking her questions about Kevin Gates. She get the stuttering and shit. That ain't no real relationship, man. That's some clout shit they got going on. All right, but this is what I want to show y'all. Look a while ago, man. Brick Road Lord Steve, last night you was in my dreams. You gave me a hug, bro, that I needed more than you can know. I miss you. Thank you. Yeah, look at this nigga, y'all. This nigga Wallow is a character. Look at this shit.
Yes, man.
Look at this shit, man. Like, these niggas, yo. Yo, these niggas is wild, man. What the fuck? What's up with yo, man? Why is he crying? Like, yo, tighten up, my nigga. What the fuck is you doing? Yo, the bitch crying on camera and shit. You think this shit cool? Like, yo, I'm sick and tired of these guys, man. Yo, we need to find a way to get rid of them niggas. Like, we don't need this shit.
Help me so much, man. My brother. Think about my brother, man.
Hell no.
I think about everything I lost in life.
He ain't crying, bro. He faking.
You give me so much hope, man. There was times, man, I didn't know what to do, man.
Look at him.
I listen to your music, man, and you just...
Nigga faking, man.
I like you, man. I like you.
Niggas is clowns, man. What a little fucking goofball. Hey, what the fuck wrong with these? Yo, what's wrong with these guys? Yo, where the fuck did they come from? That shit fake as a motherfucker. He ain't shed not one tear. He just put on the whole show. What the fuck is he doing? Yeah, nigga just put on the whole fucking show though. We ain't watching it again. Hey, that nigga crazy. What's this for entertainment purposes only? They need to put a disclaimer at the bottom of the video. For entertainment purposes only. This is not real. Like, these niggas is crazy. You might as well join reality TV.
I've been waiting for so long, man. I never thought I'd meet you, man. I just never thought, man. You just don't know, man. There's so much. I've been through so much, man, and I was just listening to, and I would listen to your music, and I get out of a bad place. Everybody think life, they just think 'cause I'm happy all the time, everything is all right for me, and it's not. And I would listen to you, and it would just.
Hey, yo, fuck out of here. I'd have been like, yo, I ain't gonna lie, bro. Your music got me through some tough times, my nigga. You know what I mean? Gave me that. Yo, keep going. But all this shit, like, he act like this is long lost brother or something. Like, nigga, get up, nigga. Hey, yo, if I was you, I'd have told his ass, get up. Hey, yo, if I was him, I'd be like, oh, wow, get up, bro. Like, go get up off the ground, my nigga. You looking crazy. Got me looking crazy, too.
I love you, man. You're the greatest.
It look like a party. Yo, watch one more time. I ain't gonna say that this time.
Yes, man. Music helped me so much, man. My brother. I think about my brother, man. I think about everything I lost in life. You give me so much hope, man. There was times, man, I didn't know what to do, man. I listen to your music, man, and you just.
Man, bluffing like a motherfucker.
I like you, man. I like you. Man, you just, you know, I've been with you for so long, man. I never thought I'd meet you, man. I just never thought, man.
Hey, I never in my life be that happy to meet anybody. Like, I don't give a fuck who that is. You can be my motherfucker. That's he act like that's his father. He ain't saying since he was born or something. Hey, that's how a nigga be when a nigga see his father when he 12. And you ain't saying your father locked up your whole life. and he come home when you 12. And look, and he pop up at your school. Hey, yo. He pop up at your school and shit. Like, oh shit, my pops. That nigga wild or weird and shit.
You just don't know, man. There's so much. I've been through so much, man, and I was just listening to, and I would listen to your music, and I get out of a bad place. Everybody think life, they just think 'cause I'm happy all the time, everything is all right for me, and it's not. And I would listen to you, and it would just.
And you always gotta brag. Those niggas do a lot of bragging. Yo, these niggas are selling us out, y'all. They selling us out. Them niggas are sellouts. But look at the comments. The dumb black people. I was gonna put laughing emojis in there, but I ain't want to be out of place. I already put like 7 laughing emojis in there. Like, yo, what the fuck? Why don't get your silly ass up, nigga? Look at all fucking stupid. So for finesse 2 times. Attorneys quit on him. God damn, finesse. You just did all that talking and you ain't pay the piper. It said on May 2nd, 2025, the defendant and undersigned counsel entered into an agreement for legal services for counsel to represent the defendant in the supervised release revocation hearing. In exchange, the defendant would make agreed upon payments over a fixed period. The defendant has failed to make any payments toward attorney fees in this case. The defendant is indigent, and he is now unable to fulfill the financial obligations previously agreed to. Counsel has notified the defendant family of his intent to withdraw and will notify the defendant with his intent to withdraw. The address of the defendant is set. I guess that's it. God damn, man. Why ain't pay them people finesse? Gotta pay to play, baby. Yo, look, y'all, they made a list of people that we need to get rid of. Setting black people back. Sexy Red, Lil Nas X, Aaron the Plumber, Tyreek Hill, and anybody similar. Playboy Cardi, the niggas that run 20v1s, South Chicago and Atlanta. Yo, I agree with the first 6. All of these people hold the black community back. She's a fucking industry plant. He is too. This nigga is online acting like a buffoon. I don't know what's wrong with Tyreek Hill. Why they put him on there? Playboy Cardi wear fucking thongs. And them 20v1s is fucking stupid as hell. I don't like nothing about them. All of them staged. Not even just the people that not even. Yeah, I agree. The niggas that run it, yeah, I think they're a problem too. I seen one other day where a little Mexican kid posed a course from head. It looked like from a tranny. Like, y'all, this shit's staged, man. Stage actors. Yeah, but yo, I think we tripped. I think we had a good one today, man. Tripping off everybody. Y'all know we be live. We gonna live at 11 tonight too, y'all. So make sure I tap in if they don't send notifications. We will be live at 11 tonight Eastern time. You know what I mean? But make sure y'all subscribe to the channel. Appreciate everybody that tapped in. If you can support the platform, my man Alvin posted it at the bottom. Baltimore swag. Share the live. Hit the like button if you didn't. It's another day. Keep it G News. And I'm out.